My lord, I'm seeking your lordship indulgence to allow us to move a petition tomorrow, my lord, relating to, my lord, Kavura selection and appointment stipulation of age, my lord. Earlier,
We are not having bench three. We are having bench one. Last week we were bench.
My lordship, I mentioned I for the policeman tomorrow because this is an eviction matter. Only the rate of delivery of poison will be issued against us. Please,
Civil bench one matter.
yes, civil one matter.
What is the matter?
We are not made a party in the suit. Exported decree has been passed against us, and we filed a petition on Order 21 Rule 97. It is in the evidence stage, and in spite of that, they have acting for the issue the rate of delivery of poison.
Why didn't you ask for an injunction for the court adjudicating
We have prayed before
2197?
Yes, we prayed, but it doesn't pass.
It has been refused or what?
It refused.
Tomorrow?
Tomorrow,
Have you filed on?
I filed an IA
In the
in the civil division petition. Because subsequently, this order has been passed on 11/9.
civil division is in the context of what? What have you challenged?
The interim order will be passed in the executing court. After that, this
There is no stay order.
is on the stay order.
Item number 9, the second appeal, there is a cross appeal also, my lord. So my instruction is not to press the matter. So for the other cross appeal is concerned, my lord, SP Chaudhary consulted me yesterday, my lord. He is not here. He has no objection if the matter is closed, my lord.
So what about the cross appeal?
That's why, my lord. I took a consent, my lord.
Both the matters.
Both the matters, my lord. Trustee may record it. He has consented to that, my lord.
No. Whether he's withdrawing the cross appeal.
Yes, my lord. He said that the matter is closed.
P. Chakraborty, Senate Counsel for the appellant, submit that he has instructions not to press this appeal. So he has also informed this court that in the connected cross subsection inform this court that in view of such instructions, the opposite party, the respondents who had filed a cross objection being CO4 of 2012, represented by SP Chaudhary Senate Counsel, would also not like to press the cross objection. According both the appeal and cross objection are dismissed on withdrawal.
Item number 15, lawsuit is hearing matter.
1-5.
Lawsuit. I am for the appeal and lawsuit. However, lawsuit, the counsel for the respondent, lawsuit, Mr. Bhatta has informed me that he is not coming to the court today.
Okay.
Lawsuit on Thursday or lawsuit on next Tuesday.
Sri J. Kolita Senate Counsel for the appellant submit that he has been informed by the other side of some difficulties today. List after a week.
May I please, my lord?
Yes.
My lord, with due consent from the other side, my lord. My learned friend, I beg to mention item number 13, my lord.
1-3.
Lord.
Yes.
Matter may kindly be taken, my lord, in the month of November, my lord, Mr.
18 minutes.
Matter, my lord, Mr. Gaur will appear. That's why, my lord. Because you are
It is agitated last week of
Typical 18 minutes. We can adjourn you accommodate for some time, but not till say it was an 18 minutes.
my lord, just to the application, my lord.
You have to make already better. 1 day, 1 week. But had it been a matter of 22, 21, it would have been 18 minutes. A prayer for adjournment has been made on behalf of the appellant. Also, the matter is the appeal is of year 2000. Therefore, though the same is adjourned, 18 minutes. That the matter be adjourned for a limited period of 2 weeks.
Obliged, lord.
The date will pick the court.
Are it? Yes.
But I beg to mention this matter not in today's list. Madam, this is the restoration application which has been filed by the other side. I am the decree holder. This is a matter pertaining to the year 1960. And madam, this was dismissed for default twice by this honorable court. Madam, this application was filed by them on 1st of this month. If it may please be directed to be listed.
The second appeal over.
Madam, this is a civil revision matter.
Civil review. Have you not filed it?
Deeply applied.
May I please, Lordship, with due consent of the appellant, Lordship, I beg to mention item number 10 and 11, Lordship.
Yes.
Lordship, this matter may be adjourned for 2 weeks, Lordship. I am appearing for the respondent.
14 matter.
If Mr. B.N. Sharma is not well, Lordship.
You have to make alternative arrangements. We can grant you time of 1 week, not more. Next Tuesday.
Obliged.
A prayer for adjournment has been made on behalf of the respondent on the ground that the learned counsel is not well. Considering the aforesaid ground and also the fact that the appeals are of the year 2014, a short adjournment grant directing listing of the matter on Tuesday next month. Tuesday 26. This will be 9 and 10. Madam, 9 and 10. 10 and 11.
10 and 11. Obliged.
You are there. Madam,
May it please
yes,
your lordship.
done.
Well, with the consent of the other side, I beg to mention item number 4 of the daily list, my lord. Now, Mr. D. Saike is in bereavement, my lord.
Oh.
I paid at a mathematical entry.
4.
And for the respondent.
You are led by Mr. Saikia
Yes, my lord.
for the petition
Yes, my
on a prayer made on behalf of Priti Saikia, present senior counsel, appearing for petition. Matter is adjourned by 2 weeks.
yes. Keep your
May I please, Lordship, I beg to mention for matter for listing.
Listing. What
Listing.
matter?
My Lordship, this matter is earlier occasion, this matter is filed, but some part.
What is the matter about?
This matter.
This is not the bench. Are you mentioning a writ petition?
Yes.
We are not having writ petition. Civil bench one. You have to go to bench 3.
Your Lordship, kindly the matter may be passed over 40 days, as the engaged counsel is not well.
For the date 2010 matter.
Yes, Lord.
Who is not well? Mr. Das.
No, S. Roy.
Day after tomorrow then. It is submitted that MSS Roy, the conduct counsel is unaware. However, the matter is of the appeal is of the year 2010 and has been listed under the column within inverted comma of the para. In any case, a short accommodation is granted for this grant, and the matter will be listed on chapter 121. Day after tomorrow, to no adjournment. Yes.
Item 2 also, Lordship.
Same council.
Let's
What
This matter, I am for the respondent.
The matter passport for the timing. My senior is on leading court number 1.
is the matter?
The matter pertains to section 6 of the specific relief record. Whether the suit of the plaintiff was
We have filed this suit under the specific relief act, under 6. And then it was decreed in our favor.
Thereafter,
Since section 6 is not appealable, I have filed the review.
Okay.
So as per the judgment of the lower trial court, Your Lord. Basically, the evidences and everything is in my favor. I am in possession.
What are your grounds?
They only say that they were the only two.
Mr. Ganguly is there. You will wait for some time. Let him-
Yes. Rakib, I have another matter.
You come, do your matter. Come. Writ petition, why?
Same problem, top of the list it was. Most probably it was allotted to this bench.
Assigned to this bench.
Yes, my lord.
No problem. Yes.
My lord, other side could have been here. It will take only, from my side, I'll make only 5 minutes.
Yes,
argument.
you could finish it up. Is it on the top of the list?
Yes, yes. It's in admission column, but it is
Assigned.
assigned.
Yes.
My lord, would your lordship be pleased to note 2-3 dates and then
Yes, yes.
my lord, this Assam Education Provincialization of Services of Teachers and Reorganization of Educational Institution was published in the Assam Gazette on 11/4. My lord, that date could be recorded.
11/4, 12,
No, 11/4/2017.
17.
My lord, if your lordship looks at the order, I think from that order also it is there already mentioned that order of 10/2/2023. The order passed in this case. Over there it is there. Or your lordship. if may-
10 to,
10/4/2014.
no. The order,
Order, my lord.
10 to 2023.
Yes, my lord. 10/2/2023.
Okay.
My lord got it.
Give you narrative effect.
My lord, then by notification dated 12/5/2017.
Hmm. Yes. Who is on the other side?
Education Department. My lord.
Madam, can you have somebody from the education department? This is a matter assigned to this bench. So they'll be probably in the bench too. Call somebody who has been
Second.
equipped with the record. Yes.
My lord, then
But why 23 matter is out?
My lord?
Why 2023 matter top of the list? Okay, it doesn't matter.
my lord, then it was
You'll be appealing. He has just started.
my lord, the section 3(7), which we are concerned, that was notified in the extraordinary gazette, my lord, on 6/6/2017. That is the important date, my lord.
Which one? 3/7
Yes, my lord.
of the,
Of the 2017 Act.
in this book, which page?
My lord, this book, my lord, if you lost
Yes.
then I'll directly bring to the page, my lord. Page 110.
110.
Yes, my lord.
Yes.
Is it there, my lord?
Yes.
7. Now, my lord,
Which clause you are referring to?
my lord, 7.
317.
Yes, my lord.
That's it.
My lord, in the 5th line, the crucial part is at least 10 students must have appeared in the last final examination in that particular subject from that institution. Your
You are
Lordship, got
reading, 3, section 3,
my lord, section
1,
317.
1, 7.
My lord, another thing your Lordship could note down, my lord, this provision is also amended on 18/5/2018. If your Lordship looks at that, 7 is a star mark one.
Yes.
So my lord, that date is also crucial, my lord. 18/5/2018. It is an amended provision, my lord.
Yes.
And my lord, we have to keep it in our mind one thing, that this act was finally implemented when the benefits were provided. It was in the year 2020. And my lord, if your Lordship reads that, if I come to the 7.
Yes.
May I read it, my lord? For provincialization of services of one teacher or tutor, as the case may be, in each subject, including the core subjects, in case of venture high school or venture high madrasa or venture high secondary school or venture senior secondary school. This is venture senior secondary school. At least 10 students must have appeared in the last final examination in that particular subject from that institution. My lord, if your Lordship looks at the page 99 of that beginning of the act, my lord. My lord, this act got the governor's assent on ultimately notified on 11/4/2017.
Yes.
Your Lordship got it. Now, my lord, would your Lordship be pleased to come to page 101?
Yeah.
That is the notification. And on 12/5/2017, the notification was issued in respect of this act. And ultimately, my lord, the last line of this notification, published in the Assam Gazette Extraordinary number 251 dated 6/6/2017. Just above the definition.
Yes.
Your Lordship. Now, my lord, I'll just.
You have said this 11/4 is what?
11/4 is the governor's assent published,
Not the Gazette.
not the Gazette. Gazette is 6. Gazette is 6/6. 6/6. And definition and the clause 1(3) reads that it will be effective only from the
Yes.
my lord, if my lord looks at 1(3), it shall come into force on such date as the Assam government may by notification in the official gazette appoint, and different dates may be appointed for different provisions of the act or for different category of the 1(3). That is page 101.
Yes.
So though the governor's assent notification was in the month of April, ultimately this came into force by Assam Gazette on 6/6/2017, my lord.
What is the meaning? It shall come into force on such date as the state government may by notification in the official gazette appoint. That means mere publication in the official gazette is also not the appointed date. In the official gazette, there a date has to be there that it is from this date when the act will come into force.
Not exactly the act.
The
This-
particular provision.
Yes, yes.
And because the second line is said, and different dates may be appointed
Yes.
for different provisions.
Yes.
See, it is the act, because if you read one short title, extent and commencement, this act may be called so and so. Okay.
Yes, ma'am.
Number two, it extends to the whole of Assam.
Yes, ma'am.
We are still on the act
Yes.
as a whole. Then it says it shall come. It means the act shall come into force on such date as the state government may by notification the official gazette appoint. And different dates may be appointed for different provisions of the act for different category of in the gazette itself. Different dates may be appointed for different provisions. So far as relates to different institutes.
So the notification is there. That notification is 12/5/2017.
Which notification?
Immediately after 1/3. Except 4 and 8, rest were notified
This one.
on 12/5.
We have from 5th of May.
Uh,
We have from 5th of May.
5th of May, but it was notified 5th of May, but Gazette publication was on 6/6/2017.
Understood, but by the gazette, the date has been fixed.
Okay. Take it for example, 5th of May.
5th of
Okay.
Gazette is dated. Gazette is 6/6. Appointed date is 5/5.
Yes.
Yes.
Now one thing, now I come back to 317.
Yes.
My lord, in respect of the higher secondary school or the venture senior secondary school,
You are a venture, but higher secondary.
my lord, now the higher secondaries are known as senior secondary.
Venture higher secondary.
Yes, my lord.
Yes.
My lord, if your lordship, from the 5th line, after that word venture senior secondary school, at least 10 students must have appeared in the last final examination in that particular subject from that institution. That is the only line, my lord, in this case, in this proceeding, my lord. At least 10 students must have appeared, not even passed, must have appeared in the last examination. So now the question is, which is the last examination? My lord, if your lordship looks at the writ petition,
Yes.
my lord, page 33,
3/3.
33, annexure 7, my lord.
Yes.
My lord, this is the higher secondary final examination timetable, my lord. It starts from February 20, ends March 20. 2/2/17 to 22.
Yes, yes.
My lord, now would
What
your
is your
lordship,
subject?
my lord, would your lordship be pleased to
What is your
economics?
Economics.
My lord, would your lordship be pleased to see page 35?
$35.
35.
Yes.
My lord, though it is a typed copy, I can go to 36, my lord.
Doesn't matter.
My lord, 11/3/2017 is the date, my lord. My lord got the date, my lord. Last.
Yes.
And subject is economics. Total students appeared 13.
Yes.
Now, my lord, for another added argument would be, my lord, as your lordship is aware, the 317 is a amended provision now as on date, which was amended on 18/5/2018. 18/5/2018. Now, if your lordship looks at page 37.
Yes.
My lord, the routine is from 23/2/2018 to 22/3.
Yes.
And my lord, 2018, the page 39 is the document, my lord, to show in 2018, total appeared 11, my lord.
39.
Yes, my lord. Center code is 29. Total appeared 11.
In economic.
My lord?
Economic.
Yes, my lord.
Center code is 29.
Yes, my lord. In 2017, also 29.
Yes.
Now the whole case is
How many students? 11.
11. Yes.
Okay.
Now, my lord, in my brief, the examination of 2017 ended by March. I appeared. Till then,
You did not appear. Your students appeared.
yes. So till then, I do
Yes.
not know.
You
in-
also appeared with your students
Yes, my lord.
to increase the numbers.
So, so examination ended. My lord, in Assam, all the high secondary examinations are by March, it ends. So in this particular case, 20th March 2017, the examination ended for 2017, my lord. My lord, March examination ended. I, as an petitioner, I do not know that in the month of April, some act will be given assent and ultimately it will come into extraordinary gazette in the month of June. So for me, my lord, if it is said 10+ students appeared in the last examination in this act of 17, my lord, simple English, as far as I understand, last examination means the examination just got over. It is not the past, it is just appeared. So in the month of March, February, March, the examination which ended would be the last examination as far as this 317 is concerned.
Yes,
My lord, the added argument would be if my friend from the other side would say, no, we cannot consider the 17, we have to consider 18 because it is an amended provision and ultimately the act, the result of the act came in the year 2020 when the first batch of persons were provincialized. So 18 also, if they take, because 18th also it was before the examination of 2018. Means the act was after the examination. Examination ended in March.
yes, yes, understand.
Now, my contention is that the last examination where the students appeared, as far as this act is concerned, it should be 2017, February to March, because the act came after that. It said 10 students appearing in the last examination, not even the it is passed or anything, just appeared. So in 2017, before the act came, 13 students appeared. And in 2018, 11 students appeared. As far as the provision of the act is concerned, it is 10 plus, my lord. At least 10. It's not 10 plus, it's at least 10. So I am above 10. My provincialization, while my counterparts in the same institution were given the provincialization, I was not given the provincialization on the ground and what they have said in their affidavit. That
Yes.
in 2016 examination, I had only 9 students.
Yes.
But over here, while dealing with the case in the initial stage, in other elementary schools, normally the primary and the upper primary, it was considered as the previous year. So year, if it is 17 act and it is previous year, then it goes to 16. Keeping that in head, they have considered everything to be 16 and where I have been victimized. Over here, as far as the act and the provision is concerned, it is clearly written, last examination, 10 students, last examination appeared. And examination being in the month of February and March, act has come in the month, act got the assent in the month of April and thereafter gazette notified in the month of June. I believe, my lord, my case should be considered as the year 2017 and not 2016. That is my only case.
Yeah, our only contention is that the act came into force in the year 2017. So whatever exercise we have done, my lord,
Act came into force
in the year 2017.
2007.
17,
That is 6617, my lord.
with effect from 5th of May.
5th of, right?
So while considering the cases for provincialization in all school, my lord, we have considered the last year as 2016.
Here it's not the last, here is the last examination.
Exactly, my lord. Last examination we have considered as 2016.
Last examination, will it be 2000?
That is the only stand we have, my lord. Because in all cases,
No, Mr. Khatri,
Yes, my lord.
you may have some reasons to fall back on the previous year. Is there some justification? You
Yeah, my
may
lord.
have some justification.
here, my lord, the word used is last, my lord, in this particular
Last examination.
last examination. In particular provision,
Last examination, Bedin has contended that you go by literal meaning. Last examination is the examination which was held just prior to the coming on force of the act.
yes, sir.
So that way literally is the examination of 2007. If you want to contend to know by last examination, we meant the examination held in the last year.
Yes, my lord.
That for that interpretation, you need to have some basis. The section may not support you, but do you have anything else to contend to support your contention?
In our
What he, Mr. Abedin, has fairly contended in some cases, you have taken previous year.
yes, my lord.
So that have may play something in your mind. What was that? What's the previous year concept?
Yes,
My lord, I'll just point out one thing if your lordship permit.
And this is not like an income tax that there is an assessment year, there is a previous year. Financial year is different.
yes, my lord.
Here, the qualification is what? Last examination.
Last examination.
Last examination, and he is going to another extreme argument that even if you take the amended provision,
Yes,
that was an 18,
Yes,
then also 17, it becomes the previous year, going by your interpretation.
yes, my lord.
But we may not even have to go to that aspect.
Because we are not in the amended provision.
That is why we may
Entirely,
not
but-
go into that aspect. What did you say in your affidavit?
In page 43, my lord.
Just
In internal page 4, my lord, then continuous page, my lord, page 43.
you're for secondary.
Secondary, my lord.
What is the paragraph?
It's the paragraph starts at page 42, my lord, paragraph 5. The relevant line, my lord. 6 line from the top, my lord.
Yeah.
The line starts with, my lord, since the Act of 2017 came into force with effect from 5/5/2017, except the provision of section 4 and 8. Therefore, the last final examination is considered to be the final examination held in the year 2016.
Well, you're reading paragraph 5,
It's my paragraph 5 in page 43, my lord.
42, 43.
43, my lord. From the 6th line, my lord. From the top.
Since the act.
Since, yes, my lord. Since the Act of 2017 came into force with effect from 5/5/2017, except the provisions of section 4 and 8. Therefore, the last final examination is considered to be the final examination held in the year 2016.
Anything else?
No, my lord. This is the only stand we have taken in our affidavit, my lord.
The short question which has arisen for consideration in this petition is that interpretation of section 3, bracket 1, bracket 4, Roman 7. For issue of provincialization of service of teacher substitute in venture, higher secondary, and the fulfillment of conditions for such provincialization. Para- The petitioner has contended that he was appointed as a subject teacher in economics, as a lecturer of the subject in economics in the Baghmara or PHR Junior JUNIR College in the year 2002.
It is junior, actually, typographical error, junior.
Junior, sir. Any other typographical error?
No.
In the year 2000, also, the state college was a venture college at that stage, and the appointment of the petition was as per a resolution date 17/8/2002. Also, it is contended that the college had received the final conference on 12/8/2005 in respect of 9 subjects, including the subject of economics. Para- In the year 2017, the Assam Education within bracket, bracket close Act of 2017 was enacted, which was with the object to consider various educational which which were received, which had received permission for first year class and conference from the authority on or before 1 month for provincialization of services of church public tutor. The a certain date which would be crucial to the issue involved are noted herein below. The Act had received the assent of the governor on 6/4/2017 and was published, which was published on 11/4/2017. The same was published in the Gazette on 6/6/2017. as per section 1 within bracket 3, comma, it was provided that the act would come in force on such date as the state government may by notification in the official gazette appoint. The gazette notification which was published on 6/6/2007, comma, as stated above, had notified the date on which the act would come into force as 5/5/2007. Full stop. Para. The relevant provision of Act named section 3, bracket 1, bracket small 7, which based on the condition for giving the benefit of provincialization is expected here. 317. The requirement of the grievance of the petitioner is that his case for provincialization has been rejected on the ground that that the conditions laid down in the aforesaid provision are not met. Sarah, I have heard Sri J. Abedin, Learned Counsel for petition. I have also heard Sri N. J. Katonier, Learned Standing Counsel, Secondary Education Department. Full stop. The department has also filed an affidavit in opposition on 16/8/2020. Para. Sri Abedin, the Learned Counsel for the petition, has submitted by referring to the document annexed to the petition, has submitted that in the higher secondary examination held submit that the higher secondary examination of the year 2007 was held from February 2007 to March 2007, and it is not in dispute that the total number of students appearing in the subject of economics were 13. Full stop. It is the case of the petition that the condition of having at least 10 students appearing in the last examination has to be construed to be the examination held immediately prior to coming in force of the act, and the plain meaning of the aforesaid provision is that it is the examination which was concluded, which was held between February 2007 and March 2007, which would be the relevant examination. The Learned Council has also submitted that the aforesaid provision was substituted by an amendment in the year 2015 by a Gazette 50 dated 18 May 2008. Full stop. By referring to the relevant documents, comma, the Learned Council has submitted that even for the higher secondary examination held higher secondary examination for the year 2018 held in between February 2018 to March 2018, comma, the number of students who had appeared in the subject of exam were 11. The evidence the Learned Council accordingly submit that under both conditions, comma, the petitioner fulfill the requirement of act, and therefore provincialization of, and therefore, comma, rejection, and therefore, comma, provincialization of the service could not have been rejected. Full stop. Well, on the other hand, the attorney, the Standing Council of the department has submitted that the consideration of the petition cannot be done on the basis of the substituted route of 2008, but and therefore the reference to the examination, higher secondary examination of 2008 will not come at all. So far as the reference to the examination, to the higher secondary examination of the year 2017 is concerned, comma, the Learned Standing Council submits that even that examination would not be relevant, as the last examination appearing in the aforesaid provision would mean the examination held in the previous, which in this case would mean the higher secondary examination of the year 2016. It is the contention of the department that in the said year of 2016, the number of in the Department of Economics was less than, were less than 6, were less than 10.
Nine to be precise.
Less than. Para. The Understanding Council has specifically referred to paragraph 5 of the affidavit in opposition dated 16/8/2020, the relevant part of which is expected here in below. Page 1. Para rejoining his submission, comma, the Abedin, comma, the learned counsel for the petition has submitted that the interpretation sought to be given by the department would not be reasonable and would rather in conflict with the plain meaning appearing from the provision of law. Para. The rival contention advanced by the learned counsel for part have been duly considered, and the material placed for this court have been carefully examined. The relevant provision of law has already been expected above. The controversy in this case is only with regard to meaning which can be assigned to the expression last final exam. The expression used, namely last final examination, is not qualified by any other provision which may give the department to contend that this is the examination held in the previous. When the statute in question is plainly constructed, comma, there is no scope to give any other meaning than the one which plainly appears, which appears from a plain reading of the statute. Under the principles of interpretation of statute, comma, it is the plain meaning which is required to be taken into consideration unless a plain reading does not make any reasonable construction. In the instant case, comma, there is no dispute with regard to the fact that the examination of the year, higher secondary exam of the year 2017 was held and completed, was held between February 2007 to March 2007, and the expression used in the state is with the appearance of at least 10 students. The department has not disputed the data produced in this case with regard to the number of students which has been project 13. Under those circumstances, this court is of the opinion that denial of the benefit of provincialization of service by giving an incorrect meaning to the provision of law is not justice. according to this court of the appeal, that case for interpretation. Now, case for interference is made up according the consequence. Is there any rejection or
No.
consequence, the writ petition is allowed by holding that the petition had fulfilled the requirement of section 317 of the Act of 2007 and therefore entitled for regulation of the service. The authority, namely the director, would be the authority,
Director, madam.
director of secondary education, is according direct to pass necessary orders in this regard within a period of expeditious and within an hour of 60 days.
My lord, would your lordship be pleased to see my second prayer, my lord? Second prayer,
Forward.
my lord, with effect from the date when my other teachers were. I get it.
Since the petitioner has been held to have fulfilled the requirement for provincialization of his service, the effect of such provincialization be given from the date when similarly situated persons were provincialized. However, such effect would only be notional for the purpose of seniority and fitment. And
No, I'm serving.
Huh?
Continuously serving.
no, not for the money.
Obviously, I'll get the money, my lord. My lord, one thing I'll just say, he's a tutor. He'll not get anything.
No.
My lord,
Your
after,
services are being provincialized. That I think you should be happy enough.
my lord, this is the this.
Not only national, but
My lord, not it be, my lord, not optional, my lord. My lord, I deserved it because they wrongly interpreted and did not
so
give.
you are getting it.
My lord, all my counterparts are getting it. My lord, it is the absolute case where I deserve that as a tutor, my lord.
Sure.
After 20,
That will not be.
my lord, after 20 years of service, my lord. Then, my lord, that
Okay. Full stop. As regards the claim for salaries for the period, the petition may file appropriate application for the authority, which may become recorded.
my lord, that is okay, my lord. Only that notional part, if it is notional remains, they will not understand, my lord.
They will not understand. That
Yeah.
part we have already given.
No, what-
Salary part is left them.
Yes, my lord. What my lord has said that only that notional part should be removed. I'll file the application.
Now what do we write there?
My lord,
We will not give you any benefit.
no, that benefit, my lord, without that notional part, that benefit, I'll file the application. And I believe they will,
National part we have granted. The others they will grant.
my lord, over the first part where my lord has mentioned the
Then
notional.
remove everything.
No, not that.
Some part we wanted to protect you. That seniority, fitment, everything. Rest for back pages you
But I believe, my lord, I deserve that back to
have to file.
I'll file, but
File. Because there are case laws here and there. You may be correct in content because your entitlement had occurred then. You may be correct. This let you file an application.
Oblige.
oblige, my lord. Only thing, my lord, once said notionally, then subsequent
Social
filing-
is here is what we have granted. Others they will grant.
that would have included my material gain. Now it's not there.
You should have said this before. Would have considered something. Yes. Next
Deeply obliged, my lord.
Your Lordship,
item.
Your Lordship, in this matter, I have received instruction and accordingly I file affidavit, Your Lordship, and send it for vetting. It will come from Mumbai.
Madam. Here for the railways.
Yes, sir.
Third, MFA, why affidavit is necessary?
Instruction they have given you a lot. That's why
No,
I want
see,
it to
in an
give.
appeal, will not, there is no question of any new pleading. We'll go by what has
Yes,
happened in the tribunal.
yes,
Your written statement, their claim petition,
yes,
and the evidence.
on that only I have filed your lot.
Why do you need an affidavit? Where is the concept?
Instruction I have received your lot. That's why I'm
That
already
instruction
wanting
also-
to keep it in the record.
New instructions you cannot incorporate in an
This
appellate.
is not new instruction. It is according to the, it based on the tribunal, your lordship, that instruction.
So that was already there in your
In the
statement.
written statement.
And whatever contention you have, you can already contest. The 23 method will run to time, but you can advise your clients that there is no requirement of filing them. This is not a repetition.
Yes, your lordship. This is first statement.
Everything depends on the record. We will not even go by what they have pleaded here. We'll go by the record.
Yes.
Heard,
Shall I file or not, your lordship?
also heard if considered who submit that an affidavit of which has been filed, has been prepared, which has been sent for vetting. The learned counsel, according to grace, and is granted 3 weeks time.
Yes.
3 weeks time, file the affidavit.
Please, Your Lordship.
Oblige.
What is this? Some correction.
Correction, Lordship. We'll find it, page number 14,
14. 1-4.
1-4.
Unarmed to armed.
Unarmed branch to armed branch. Actually, it will be the armed branch to unarmed branch.
Heard. That is the only one.
That is the
In
only
the
one.
first part, it was correctly written. The first part of the judgment was correctly reflected. In the first part of the judgment, it was correctly reflected.
Yes, first part is correct.
Only the last part.
Only last part.
The Abdul Mazumdar, learned counsel for the applicant, who has filed the application with a prayer for correction of a certain portion in the order dated 29/8/2023, passed by the court in WPC. One 081 of 2020. The issue was with regard the claim of the petitioner for consideration of their case for transfer from the armed branch within bracket AB to the unarmed branch UB in the Assam Police. The applicant of the petitioner are worked as armed branch AB constable in the concluding part of the judgment, comma. It has, however, there appears that there are typographical error had crept in, wherein the direction instead of direction was issued wherein, comma, instead of a direction for consideration for transfer from armed branch to unarmed branch, comma, the reverse had occurred, namely unarmed branch to armed branch. Full stop. That this court has examined the state fair in the context of the fourth order. The contention Anyone and from the government? Anyone with you, Mr. Government? Anyone?
Well, I'll
No, you can name anyone. Who is any government?
well, there, Deepali Das Burman. He was just in the college.
Okay. Also heard MSB does government. Learned State Council. Correct. The content of symbols that appears correct and in the state order, comma, a typographical error had occurred in the second last line of the same. Correct. According to comma, the instant I is allowed by direct by observing that the expression unarmed run to armed run may be read as armed run to unarmed run. For all practical purposes, comma, it is clarified that the consideration of the case for transfer from the armed branch to the unarmed branch of the Assam Police is to be made in accordance with earlier order. This order repeated to be a part of
One
the
more
order dated 29/8.
one more submission subject to the approval of this court that transfer that exercise may be completed on or before the 31st December of current year.
That we cannot say. That in the next meeting, it was based on senior. That part we had considered. Mr. Chutke, we had heard. Yes. I sense.
Obliged, Doctor.
Where is Mr. Mannan?
Mannan is in 420, man. Formed by his.
He was there. He said he would come.
Yeah.
What is the matter?
Well, this is a revision against an order of the Learned Munsif against relating to section 6 of this specific. Yeah, no appeal lies, so revision has been filed.
Yes.
And
What are your grounds?
Well, we have several grounds. Mainly, what has happened is that even for taking proving one's possession, because here only the possessory title is in dispute. So the main issue is Lordship will have section 6.
Yes, first let us have a look at relief for section 6.
Yes. By person dispossessed of immovable property. If I may read,
Yes, please.
if any person is dispossessed without his consent of immovable property, otherwise than in due course of law, he or any person to whom he has been in possession or any person claiming to him may, by suit, recover possession thereof, notwithstanding any other title that may be set up in such suit. No suit under this section shall be brought after the expiry of 6 months from the date of dispossession or against the government. No appeal shall lie from any order or decree passed in any suit instituted under this section, nor shall any review of any such order or decree be allowed. Nothing in this section shall bar any person from suing to establish his title to such property and to recover possession thereof. Well, read in all this really is a section which deals with not with the issue of title, because I may have title, but I may still be
Kind of
dispossessed.
a summary kind of.
It's a kind of a summary thing, but the trial court has gone into all aspects of the matter. But what the error basically committed is that the possession, the central issues of possession. Lordships are aware that it's not the casual or what we know as fugitive possession. That is not protected. What is protected is settled possession. Now, if on a particular date, if I say that if on this date I was in possession of a particular piece of land and I was dispossessed by XYZ, then I have to show that I was in a settled possession of that land. I cannot simply come across a piece of land and claim it to be my own and say that on the next day I was dispossessed. Now, that is not the protection which section 6 affords.
Offered by section 6.
Offered by section 6. Because that would lead to an anarchical situation. What section 6 protects is settled possession. Yes, I have the possession. I have documents. I have oral evidence to support that. And my central contention here is that while the oral evidence part, he managed to have some witnesses who said that he was on that property.
But the documentary evidence is completely contradictory. That is not a single document. to
If
show.
you have the title, why don't you keep the suit?
No, I do not have title as such. This is Tozi land. So neither he has title nor I have title. This is a what we known as Jalduba land. So the very fact that the witnesses have said that they have seen some person on that land is shorn of credibility, because it cannot be. And it's a swamp, half of the year it is underwater. And
No, but the intention of the statute of the lawmakers of saying that there's no appeal means that this kind of nature, this kind of litigation are something which is transient in nature, not of permanent nature.
Yeah.
It's only positioned right.
Good.
So, but do you have a substantive right somewhere else?
In an ordinary case, yes, I would have to perhaps file a suit for recovering the possession and to proving. Here, there are two aspects of the matter.
No,
One,
because
is
this section 6 itself says
Yeah.
that it give you a right to file a suit for
Yes.
recovery of position, but that will not preclude you or stand as a bar for instituting a suit of regular nature.
Yes, that is
That you can file.
ordinarily, we would have gone for that.
Madam, ready? No, we have not considered with the matter. We are just trying to know some facts. When will he be free? When will he be free?
It will take some time, Lordship.
Okay, Mr. Both of you come
But today, Lordship is taking
today. Finish up this matter.
something like
You better start your case before it's 12 o'clock.
My lord.
Why?
My lord.
Why have I said that?
Still lordship right.
For your AM Narayan.
Current PM.
Cannot be PM. Once you start, we'll allow it.
My lord.
Otherwise,
I'll finish it before 12.
even finish it.
My lord. Small issues involved.
What is AM Narayan? Why not PM Narayan?
AM sometimes
I thought it was I am Narayan.
no.
You are not Narayan. I am Narayan. Okay, I am also Narayan.
One piece is wrote his name slightly differently also.
Two matters.
Both are connected. One hearing of one matter will be adequate.
Narayan versus Bhagirathi.
My lord.
Oh my God.
All God, Dev Devis, my lord. And the issue, it arises out of a judgment of reversal. I am for the
Second appeal.
my lord. I am for the defendant. Issue is very simple and
Just appellant is the defendant.
appellant, my lord, no. Defendant is the appellant.
The appellant is the
Second case, the appellant is the plaintiff.
Second case was said to be barred by Rajasthan again filed. When this was not decided, there was no question of filing another suit.
So it mainly be
2009. Yes,
item 7.
my
Okay, appellant is the defendant.
my lord.
Suit for
Declaration of title.
title.
And also final the declaration of mutation in the name of defendant appellant is illegal, and for eviction of the appellant.
Declaration of title. Okay. And And what?
and eviction. Eviction of the defendant by demolishing the house
And eviction.
structure. Yes. Basically recovery of possession matter.
Mr. Manan, you can come after some time. We wanted to have your matter, but you were busy. We'll finish this matter, then we'll take up. Both of you come together, we'll take up. Mr.
Actually, I was.
No, I want doesn't matter. This is going to take some time.
My lord, I will just give the background before I take
Yes.
the because I'll read the finding of the first appellate trial court.
With the concurrent
Reversal.
finding of reward.
Yes. Trial court dismissed the suit and appellate court again decreed the suit by reversing the judgment of the passed by the trial court. And the facts in nutshell is like this, my lord. The land was originally a, my lord, government land.
Yes.
When the plaintiffs responded here, husband came to possess the land.
20 for possessing the
Plaintiff's husband.
who's the plaintiff?
Plaintiff is my lord, Maya Devi Bamun, Timothy Maya Devi Bamun.
He died.
Maya Devi, I think died.
Husband was possessing.
Yes. She
Name?
died and she has been substituted by her daughter.
So his name?
Ha- ha-
His name?
His name is my lord, Jay Narayan Upadhyay. Jay Narayan Upadhyay.
Okay.
Plaintiff case is that plaintiff is not admitting that it was initially purchased. Possessory right, since it was a government land, possessory right was purchased by her husband, that she is not admitting. Because I am the second wife, she is the first wife. What she is saying,
You are a lady, M. Narayan.
both, no, M. Narayan is the son, my lord, of the plate. Son.
Your name is M or AM?
A.M. The M. Narayan.
Or maybe
Ganga Devi actually is the,
maybe it was
second
Om Narayan.
no, I have seen it is M. Narayan.
That is it. Maybe he's pronouncing as Om Narayan. So somebody says OCP, then A.
Maybe, my lord.
There's no
Possibly,
me.
it will be clear from the evidence. Possibly.
He signs as Om Narayan.
Maybe, well, your lordship may be correct.
M will not have any meaning.
Normally.
And when he has Narayan,
Yes.
he'll not have a name, Western name of M.
I'll take the copy of the deposition there. From there, it may be slightly clear, madam.
Dasgupta will not help you in this regard.
No.
He's not too much interested in all this Om and M.
And going by the background, my lord, your lordship is
That is
indicating
it.
My lord, your lordship is clearly
That is it.
indicating that. They don't believe in this concept.
He's not interested also.
Yes. Yes. So what has happened, my lord? She is saying that it was originally possessory right was purchased by her father. She projected a case that it was initially possessory right was purchased by her father.
Plaintiff case.
Yes. And her father's name is Dambar Singh Pasnet.
Name?
Dambar Singh Basnet. Dambar Singh Basnet. Basnet. Then after the death of her father, the land was, annual patta was issued to her. And subsequently, on her application, the periodic patta was issued in respect of the land in her name.
Annual patta followed by KP. KP patta.
Yes, ma'am. And she paid the premium on 23rd of May 1970.
Periodic patta.
Periodic patta.
Issued later.
My lord. On
It should
she paid the premium on 23rd of May 1973.
on payment of premium.
My lord.
On 20,
3rd of May 1973.
23,573.
My lord.
Okay.
And accordingly, she has been possessing. Subsequently, my lord, in 1986, she allowed, she constructed house there,
When?
1986.
Yes.
And prior to that, my lord, she is making a statement in the plane that in 1942,
Hmm.
her husband married.
What?
Yes, this is the everment in the plane.
Hmm.
No, I'm sorry, ma'am. I'm sorry. 42, she married. Marriage with her, with Jainarayan, was in 1942.
20th marriage.
Yes. And in 1960,
Yes.
her husband married Srimati Ganga Devi, the defendant, and M. Narayan is a son through her.
One, Ganga Devi.
My lord. Her further cases, pleaded case is this, that after marriage, second wife also started staying there, and husband expired on 2/2/1989.
Ganga expired. Jainarayan expired.
Jainarayan expired.
Okay.
And thereafter, both the wives were staying together. That is an admitted fact since 1960. Man. And then she says that 20th of January 2002,
Hmm.
she directed and she requested the defendants that you construct a house and stay there. And in the evidence, something else will come. I'm just projecting what is her pleaded case. Man. Now she's saying that 20th of January 2002, she directed and requested the defendants number 1 and 2 construct their house and structures on the portion of a land in front of the scheduled land.
In front of the scheduled land.
Scheduled land itself. Within
In
the
front.
scheduled land. In front. Within the scheduled land.
On the scheduled.
On the schedule. Because subsequently she said that although we were separated, but we were staying in the same house. Separate kitchen, my lord. Lost with no smell.
Scheduled land.
My lord. And the defendants agreed to vacate the same within 20th of April 2002.
Vacate which what?
Same land where they are staying there. Now she is coming with a pleading that the defendants number 1 and 2 were direct and then requested
To have a separate house.
No, same plot of land, separate structure.
Separate structure.
And with a
To vacate what? The present house.
yes.
They are staying together.
Yes.
Vacate from the common premise. Common house.
Yeah.
Then?
And that too within a month. By 20th of April 2002, you have to vacate. Construct a house, stay there, but after 1 month you vacate. This is our period case.
No, we have not been here. She said that you construct a house on your own.
Yes.
On the scheduled land, and you vacate from this common house.
Yes.
Not from that house. You stay there.
From there.
From there also.
My statement is like this.
I don't think.
Yes. The defendants number 1 and 2 agreed and promised to construct their house and structures on the said land within March 2002 and to vacate the house and structures of the plaintiff within 20th of April 2002.
That is the present common structure. They vacate and move to the new structure.
Maybe.
No, that is the only interpretation.
Yes.
Not to construct and again vacate.
Yes. Yes, ma'am.
You leave the common house, have your own house, stay there.
Yes.
Yes. Then
And then he says that thereafter the defendants have started cutting tree and demolishing house, etc. So on 20th of April, when the defendants denied the title of the plaintiff,
then why was the suit instituted?
because subsequently in the month of September 2002, in the mutation, the name of the defendants were included.
So that's true.
To September 2000, it's in paragraph 14 of the plaintiff.
In the Jamabandi.
Yes.
Okay.
Defendant's case is very simple. There are 10, 11.
Of the appeal.
Yes, 10, 11 and 14, my lord. There are 10, 11, 14. According to the appellant defendant, my lord, both of them are co-owners.
Defendant and plaintiff.
Both are co-owners, and the suit land was purchased not by the husband of the plaintiff, but father of the plaintiff as claimed, but by the husband of both of them. There is Jayanarayan Upadhyay. Because he purchased from Vedaniti Sharma.
Jayanarayan.
Yes. And after the death of Jayanarayan, the plaintiff collusively filed this
Premium.
yes, periodic patta case number so and paid the premium of rupees 45, but from the income of her husband. Specifically, para 14. And even the land revenue was also paid. Was not paid by the plaintiff.
Premium was how much?
45 rupees, man.
4,500.
45 rupees.
45 rupees.
Minor. 1972, man.
Paid from husband's income.
Yes. Specifically, we have said the amount of rupees 45 was paid from the income earned from the property of late Jayanarayan Upadhyay. Yes.
Yes.
The further case of the defendant is that at one point of time, my lord, the name of the daughter to the first wife, there is a plaintiff, Srimati Bhagirathi Devi, was inserted, and the name of the plaintiff was also deleted. From the revenue record. And after the defendants came to know,
who had done this?
Our allegation is that they have done it.
Instead of Maya,
Yes,
Bhagirathi was inserted.
Bhagirathi's name was inserted, but without the knowledge of the plaintiff or defendant. And after they came to know about it, my lord,
And
Second.
Bhagirathi's insertion was by deleting the name of
Plaintiff.
Maya.
Plaintiff.
Maya is mother.
Maya is mother.
Father is Maya.
Maya. And yes, and after it came to light, my lord, on the advice of the plaintiff, the name of the plaintiff as well as defendant was again inserted.
Yes.
And just one more statement which is relevant, my lord. The defendant has clearly averred that plaintiff is not a legally married wife because she earlier had a husband. Without taking divorce, she came here and she started staying. So she is not the legally married wife of Jayanarayan Upadhyay.
Are you the legally married wife?
Yes.
Second
In
wife.
fact, we are claiming
Second wife.
But-
After 55.
my lord, but the trial court's finding is both the persons could not prove their marriage.
You are raising a question that she is not the legally married wife. By whom? Who's raising this question?
Trial court's finding remains, and against the trial
What
court,
did the trial court held?
trial court has held, my lord, clearly.
That no what? Please repeat.
Trial court has held that both the plaintiff as well as defendant could not prove that they are legally married wives of Jayanarayan Upadhyay.
Yes.
The wife. It's not.
Two defendants.
By the way, there's a recent judgment on this.
Malay.
Not on this. I think you know about this. I think a week back,
Malay.
less than a week, on the question of the right of
Pension.
of children who are maybe may not be legitimate. It has been the provision of law where even child born
To the
to a second wife
illegitimate.
will be entitled
Yes,
for.
my lord, that is otherwise of the section 16 of the Hindu Marriage Act.
That has been recently interpreted and decided by a larger bench. It was
Right.
referred.
I'll
It has been restricted. It has been made only to the property of the father, not
Right.
ancestral property.
Yes. Yes, my lord. I think I have seen.
Just
It will be
recent-
my lord. Yes.
I think 3-4 days back.
Yes, that was newspaper.
Yes.
No, we have it's been circulated.
It came in the social media also. I have seen that.
Is it?
It will be restricted only to the self-acquired property.
Self-acquired of the father.
Yes.
They will not get a stamp of approval for everything.
Yes.
Some restrictions has been put.
Yes.
They have given an interpretation to the provision of law.
My lord.
That's the highest.
Right.
We'll come back.
Both the parties I have already submitted my. For issues, Lord, may kindly turn to page
20.
24. Ma'am.
Yes.
Yes. 1 to 5 are not that relevant for this case. Next page, page 25, 6 and 7 are important.
Yes.
6 says, my lord, whether the father of the plaintiff, as claimed by Harman, purchased possession of the suit land in favor of plaintiff, and whether the plaintiff has been possessing and cultivating the same from the year 1950 continuous. 7 says whether the plaintiff is the owner of the suit land. So these two are important matters. Lord, you will kindly allow me to read the finding of the trial court. Slightly longish minute. If your lordship desires, I can go straightway to the specific. Otherwise, I'll read the whole thing.
Yes, yes. Wait.
Straight, madam. Lordship may kindly turn to page 31 then, madam.
31.
31. The second paragraph.
The evidence,
My lord,
the evidence.
from the evidence. From the evidences discussed above, it is found that the plaintiff in her cross-examination admitted that the suit land previously belonged to her husband, Jayanarayan Upadhyay. Although she claimed that her father purchased, she possesses right, and we say that no, our husband, Jayanarayan purchased, she has admitted in the cross-examination. In the plaintiff averred that the suit land was settled in the name of the plaintiff as annual patta land, but she has not furnished any document in support of her claim. She also admitted that the premium amount was paid out of the earnings of the suit land. She also constructed the house out of the earning from the suit land. Both the plaintiff and defendants were living together till 5 to 6 years ago. After separation, they stayed in the same house. Kitchen was separated, my lord. Your lordship knows, my lord, in joint families. She further stated that she does not know if the name of defendants were mutated in the land records over the suit land.
Yes.
Now, just next paragraph. Evidence of PW2 cannot be relied upon as she could not say the reason or cause of action for which the suit was arisen. She doesn't have any personal knowledge as to who purchased the suit land and from whom. She could not mention the core boundaries, etc. This we can skip, my lord. Next paragraph, lordship, kindly. Page
21st PW1.
my lord.
21st
My lord.
PW1.
My lord. PW1 was the same. Now, page 32, lordship, may kindly see. PW3 and PW4 cannot be relied on. Moreover, they fail to support the plaintiff. PW4 in his cross-examination stated that Jayanarayan sold 1 bighah of land given by Damodar Singh Mahajan and he purchased 28 bighas of land. He doesn't know about the happenings at Kanya Ghat since 1980. From the above evidence, I found that the plaintiff in her cross-examination has stated that the suit land originally belonged to Jayanarayan. The plaintiff has failed to prove that her father purchased the suit land in her favor. As far as possession of the suit land is concerned, DW 1, 2, and 4 has stated that defendant number 1 has been cultivating the suit land of the should be after the death of Jayanarayan and gave half to the share of the product to the plaintiff. Moreover, the plaintiff's daughter has been residing with her husband after her marriage. The plaintiff, on the other hand, failed to prove that she has been cultivating and possessing the suit land since 1950. In view of the above discussion, I find that the plaintiff has failed to prove this issue, and therefore this issue is decided in negative and in favor of the defendants. So this issue was decided in my favor. Now, next issue number 7, my lord, which is more important about the ownership, is important. This just one per page I have to read, my
32 itself.
32 and 33 particularly, one paragraph, one page. My lord, we can skip to some extent, my lord. Page 33, my lord, I'll take you to the specific place. Page 33.
Yes.
Line number 6 from top, my lord, starting from the with the words, the amount of premium. Got, my lord.
What was 7? Whether plaintiff is the owner. Whether plaintiff is the owner.
Yes, yes, ma'am.
Yes.
Page 33, line about, my lord, 6 from top.
Yes.
In the middle, the amount of premium was paid from the income of Jayanarayan's property. In the meantime, the daughter of plaintiff, Srimati Bhagirathi Devi, got her name mutated in the land record about the suit land illegally and unlawfully on 16/9/96 by deleting the name of the plaintiff. But after having knowledge of the state illegal mutation, as per advice of plaintiff, the names of defendants and plaintiff, along with Srimati Bhagirathi Devi, are mutated as co-owner of the suit land. The defendants claims that the suit property was of Jayanarayan Upadhyay and therefore they have inherited the state suit land as legal heir. The plaintiff during her cross-examination stated that the suit land previously belonged to her husband Jayanarayan Upadhyay. After his death, she got the state land mutated in her name. She paid the premium amount out of the earnings from the suit land. The plaintiff, that is PW1, during her cross-examination reports that her husband married Ganga Devi about 50 years ago. Ganga Devi had 3 daughters and 1 son, out of which Sita Devi, Kankeshwari, and defendant number 1 M. Narayan are alive. She further stated that she and Ganga Devi lived together till 5 to 6 years ago. Thereafter, they separated but stayed in the same house. PW1 further stated that suit land originally belonged to her husband Joy Narayan Upadhyay, and after his death, she got the land mutated in her name. From the above also, and also considering the pleadings to the parties, it is found that defendant number 1, Sri M. Narayan, Tankeshwari, Sita Devi and Bhagirathi Devi are the son and daughters of late Joy Narayan Upadhyay. The plaintiff and defendant number 2, Srimati Ganga Devi, could not prove as to who is the legitimate wife of late Joy Narayan. But this is what I was saying. The learned advocate for the plaintiff argued that the Pedic Patta is in the name of the plaintiff and she has been possessing the scheduled land by cultivating thereon. As such, she is the owner of the schedule. The defendant has no right to interest scheduled land, and as such, the mutation of the names of the defendants on the land record over the scheduled land is illegal and it should be cancelled and declared void in support of submission to justice, my lord. Then, my lord, next page, my lord, page 35, just 2-3 lines from the second paragraph. Learned advocate for the defendants argued that the scheduled suit land originally belonged to late Joy Narayan Upadhyay. The plaintiff in her cross-examination has admitted that she paid premium. Repeating, my lord. Can keep page 36, my lord. Just 2 paragraphs.
Yes.
Considering the pleading of the parties and from the admitted position of the plaintiff, I found that the suit land originally belonged to Joy Narayan Upadhyay. The plaintiff and defendant had been living together till the last 5 years ago and had common kitchen. It is also found that defendant number 1, Sita Devi, Tankeshwari and Bhagirathi are the son and daughters of late Joy Narayan Upadhyay. The land was settled in the name of plaintiff and plaintiff paid premium from the earnings of the suit land. The plaintiff has also failed to explain as to how her daughter's name, Bhagirathi, was mutated on the land records over the suit land on so and so by deleting the name of the plaintiff. I have already discussed issue number 6 that the plaintiff failed to prove that her father had purchased the possessory right of the suit land in her name and that she has been possessing the same since 1950 continuously. I find that as the suit land originally belonged to Joy Narayan Upadhyay, his legal heirs are entitled to it. Though the patta was issued in favor of plaintiff, I find that the plaintiff alone is not sole owner of this land. This is the finding. Now, this finding of fact, my lord, was reversed by the first appellate court only on the ground that the Pedic Patta was issued in the name of the plaintiff. Very short, my lord, page 48, Lord Mechanic.
48.
My lord, issue number 6 and 7.
Judgment is dated 7/12.
My lord. Seven 12/2006. Title appeal number
10 of 2005.
Yes. 10.
Which court? Civil judge.
Civil judge Sonitpur, Tezpur.
Yes.
My lord, I am taking a lot of straightway to page 48, issue number 6 and 7, state payment. The learned counsel of the appellant submitted during his appeal hearing that the learned lower court failed to consider that the suit land has been settled in the name of the appellant as Pedic Patta land on payment of premium on Wednesday, and so the appellant is the owner, title holder of the suit land. On the other hand, learned counsel of the respondent submitted that the suit land was originally annual Patta land and the right of possession of the suit land was purchased in the year 1946 by late so Upadhyay, that is the husband of plaintiff, who married his mother Ganga Devi, also from one Sri so, and since then the state land has been possessed, occupied and enjoyed by him. It is also admitted fact that the defendants have been residing on this suit land with the plaintiff. I have gone through the exhibit 1 issued on so and found that on so the settlement of the suit land measuring so was granted in the name of the plaintiff and premium for the state land was also paid by the plaintiff. Further, revenue receipts exhibit number so respectively also shows that premium to the land was paid on behalf of the plaintiff by her daughter, who has been staying with her mother. Again, I have gone through Exhibit H issued on so filed by defendants showing correction of the suit land was mutated in the name of the defendants also. But why correction was made, I have found no supporting evidence on behalf of the plea of the defendant. So when from the evidence on record, it reveals that the plaintiff's witness can prove by oral and documentary evidence that the plaintiff is the owner of the land. From the evidence on record, it is also not disputed that the husband of the plaintiff died in the year 1989, and since then, I have also found no dispute between the parties, but though the defendant evidence is that the premium of the suit land, which is 45, was paid from the joint property. But in my opinion, it also did not hold good when documents reveals that plaintiff is the absolute owner of this land. This is how it is reversed. In view of the above discussion, I hold that the plaintiff is the owner of this land and was in possession of the land paying revenue till the correction of the suit land on so and so in the name of defendant, and the decision of the land lower court is altered. That is it. Your Lordship is aware how a settlement of a plot of land is made under the Assam Land Revenue Registry. My Lord, a survey will be made, measurement.
From your side, there was no challenge
My Lord.
to the periodic patta in the name of plaintiff.
No, my challenge was not required because subsequently when it was discovered, because we did not know, subsequently when we discovered that by deleting the name of the plaintiff, our daughter's name was inserted, then we made an application, and it was my specific stand is at the instance of the plaintiff, the name of plaintiff as well as defendant were inserted. So after the land records, revenue records were corrected by inserting name of the plaintiff and defendant, and we are in possession all throughout my since my my Lord, entry.
What about the periodic patta?
Periodic patta. Patta, my Lord, periodic patta was issued in the name of the plaintiff, but it is not a case where, my Lord, patta is issued to a person who is entitled to it. Patta here, although issued in her name, I being in possession immediately, my Lord. Since 1960, I am in possession. So on the date when the patta was issued, even otherwise, my Lord, forgetting for the timing, my Lord, about the payment of premium, patta could have been issued only to the persons who are in possession. If nobody is in possession, they can always give it to a landless person under the land revenue. A landless person can be given. But when both of us are in possession, both of us are possessing in the capacity of an heir or, my Lord, the family member
That's
of
exactly we are trying to get it from.
my Lord.
When you are saying that the patta could not have been issued
My Lord.
in the exclusive name of the petitioner,
Yes.
plaintiff,
Yes.
there was no challenge.
Well, that's why I said this argument from them could have been valid if there was no subsequent correction by inserting my name in the revenue record as a
No,
pattadar.
see, correction of revenue record is one thing. It is mainly on the possession.
No, my
But
no,
the
no, here-
patta is that, sir, your title can be traced to the patta. Your title will not be cannot be traced to a revenue record.
I mean, two things are there. When admittedly even the patta was issued by paying premium from the property of my husband, I am entitled to it.
So that is your allegation. That and
No,
premium,
my
was,
it is admitted fact, my Lord.
premium was 45 rupees.
My Lord, whatever it is, my Lord, he has somehow admitted that 45 rupees I have paid from the income of Joynaran Upadhyay. And my Lord, more so, here is a case where It is not a mere,
So all these factors don't it come to your aid in instituting a challenge.
no, my lord, challenge,
There
that
was
is
no
what-
counterclaim.
my lord, challenge to the
You
patta.
say that the premium win was from the funds of your husband, husband the both of you. So obviously, the patta could not have been in the name, exclusively in the name of the plaintiff. You are saying that
My lord, I understand what your lordship is indicating, because what your lordship is possibly
when
indicating is
the
that initial,
patta is existing,
rightly or wrongly, initial patta was given in the
Patta
name of
is
the
there.
plaintiff.
patta
Yes.
is there.
And here is a case where the correction of revenue record, I have been muted, my name has been mutated as a co-pattadar, my lord. Now, after my name is included as a co-pattadar, it is for them to challenge it before the authority, that how could she be included?
Now, this suit has also has one of the acts of challenges holding the mutation illegal. One of your challenges against the mutation order also.
My lord,
Yes,
that
that is the declaration.
my lord, that challenge,
Plaintiff.
my lord, if that challenge is to be entertained, then suit will not be maintainable, because state has to be made a party then. At least the deputy commissioner has to be made a party. If deputy commissioner is not a made a party, that the suit itself must fail, my lord. Today, my lord, there was one more second appeal, where subsequently, because of this kind of incident, my lord, a fresh substantial question of law was inserted, that whether the suit itself is maintainable, because there also a prayer was for cancellation of mutation, my lord.
Here, the state authorities.
Not a party, not a party. In fact, my lord, I will not urge before your lordship that since there is a specific prayer for
That prayer cannot perhaps come as per your contention.
Yes.
But it cannot come with the ambit of adjudication
yes,
without the deputy commissioner being made a party.
yes, my lord. It's a settled position from my lord. I need not, at least before this court, I need not say that when you challenge an order passed by an authority or the government, you cannot succeed. If the suit will be bad for non-joiner of necessary party. On that ground, the suit must go. Because if they say that that mutation order is illegal, then suit will fail on the ground that there is a non-joiner of necessary party. Order 1 Rule 10 is very clear, my lord. Your lordship is aware of that. And my name has been inserted as a co-pattadar. That is why I did not come in. That is why they have
Where is
filed
the
the suit.
document?
My lord, yes. From the records, my lord.
Now, what is the position?
Both of us are possessing. Both of us are there.
Happy.
Happily, but she wants to have the.
So, Dasgupta, why don't you remain happy like? The Minister would like to have a look at the record.
My lord, yes.
Both of you are in position.
My lord.
Probably. I don't know.
Both of you are in peaceful position.
Peaceful position.
Peaceful.
He wants more peace. Plenty wants more peace.
What is the spelling of peace? More peace.
Now,
P-A-C or P-I-C.
Peace.
One more piece of that.
My lord, peace at this stage on the basis of land has become less important, because at this age, peace with the good health will be more important. Both of them
No,
must
there are
become
certain
very.
people who are more interested in a piece of land than peace of mind. Can't we settle this matter?
We can try, man.
Huh?
We can try.
No, we are not letting you try. We'll finish the matter.
Well.
The old matter. But why don't you settle it?
I can instruct my client.
You are both of you are sufficiently old, I think. And new generations have come in. If they don't have any issue among themselves, you are living separately, maybe in the same campus.
I can instruct my client, and if he instructs, let them sit together.
Are you in touch with the client?
Yes, yes.
You're in touch with the client.
Otherwise, poor
Yesterday I got a call. from
Otherwise,
her.
poor and not very literate also. I recall discussing once what this M. Narayan, he came once. Simple, humble background.
I think M. Narayan itself could be also now.
He
is his age?
Yes, yes, yes.
Maybe around 60 or what? No,
No, more than 50.
More, even he will be more than. No, both. Age will be, my lord.
in this appeal, is there any
Plaintiff, my lord, plaintiff was 80 years of age in 2002.
No, plaintiff died.
Plaintiff died. So
Our,
from there we can
our
find out.
daughter has been substituted.
Bhagirathi?
Bhagirathi.
Mm,
Bhagirathi is my now, not my client. She
12,
died.
22. She will be 100. So
So
son
she
will be about 80.
He is not more than 50 or 55. My client.
Bhagirathi.
Bhagirathi. 50 plus or 50.
Bhagirathi is the
Something like that.
is the daughter of plaintiff. If a lordship desires, you can make an attempt. Otherwise,
Let the
I-
matter be kept apart. Let us try.
No, but this is the old matter. We will have it today's Tuesday.
no.
We'll have it on next Tuesday.
All right. In the meantime, try. Okay.
Let it be next Monday. And Tuesday, so many matters. Monday.
Monday. Okay.
Right now, I have to call her, if possible.
And if you can get back today itself, then very good.
But today itself will not be possible for me.
First of all, it will be very difficult to contact them. And
Yes.
these people I have seen from interior places. If a phone call is made, he will express,
Malipara.
his surprise first. Who is he? Who are you? So gradually we'll have to establish contact and win the confidence, and then start the discussion of this compromise, etc.
What shall I tell her?
You have
Yep.
to create the environment for a talk.
My lord, that it will take some time to
I
create the
shall,
environment.
I, shall, I shall talk my client that court desired.
Confidence building.
Not that there's a court has directed.
Court has directed. That will be better. Otherwise, she may take it. Otherwise, court has directed to settle this matter. I shall tell in that.
Otherwise, the land will go to government.
Yes. Or in the document, in place of Pattadar, their names, our names are mentioned. So we have,
This is to come. Jamandi.
this is Jorib Kua Gaon Jumabandi.
Jamandi. After the settlement.
Yes. So we are Pattadar now. Otherwise, also as a wife of the original purchaser of the land, both of them were entitled. It is because of her trick that she has done it in her name
No,
alone.
you are the second wife.
No, first wife's marriage is without divorce from the first.
No, that is your allegation.
No. She has the trial court's finding is there. Trial court's clear finding I have read out, my lord.
No, that
None
is
of them could prove their legitimacy. Or I have told my lord, I have read just now. Both are of equal status.
Anyway, let us try. Let the matter be discussed after 1 week time mechanism. Because
Next
they have
one.
to interact.
Next one.
Next Monday.
Next one. Third,
Because
3D Mazumdar. Transylvania Council. For the appellant. Whereas the aid of the Transylvania Council is present for the response.
let there be an indication from your
Yes,
lordship.
yes, yes.
That will help me.
This appeal is against a judgment of reversal, wherein the first appellate court had reversed the judgment and finding of the trial court, which had dismissed the suit of the plaintiff respondent. It appears that in the meantime, the original plaintiff had passed away and has been substituted by her daughter. Also, this court has also been informed that the parties are related through a common father and are living in the same campus, though separate. Under those circumstances, this court is of the opinion that under those circumstances, it appears that the present may be a case where an output settlement is may be possible in view of the above, that an opportunity grant to the party to explore the option of having an output for which a week time to the necessary instruction. Depending on the instruction, this would pass necessary. If it fails, to be
Well-
finished at least as agreed to by the parties, this on 25.
Some indication from your lordship, at least by, can it be said that an out of court settlement in the interest of both the parties?
No,
That's enough.
lordship has indicated
Other-
enough.
No,
That will help us.
no, there is no indication from your lordship side. Some
We
indication.
There is a
have
possibility.
same family, same father living together.
What
Yes,
what
for-
sufficiently indicated.
You want something more? Tell us what.
So that in the interest of both the parties, what your lordship is indicating that both the parties' interest should be
Okay.
protected.
This court.
I am not saying in my favor something.
This court is of the view that an amicable settlement
Yes.
is desirable, which should be the interest of.
Yes, that is what I'm. Not in my favor.
Your lordship is sufficiently indicated.
Yes.
Anyway.
Obliged.
Try your good office and
My lord.
educate the parties from. Where is Mr. Ganguly? Is he around? Huh? This is what, Mr. Doctor?
MSc appeal.
MSc appeal.
Yes.
How much time?
Should not take much time.
MSc appeal, I don't think it takes much. Can you finish it in 15 minutes?
Yes.
To finish this, then your matter may take some time. Come at 2 o'clock. Inform Mr. Ganguly. 2 o'clock first day. Yes.
Your lordship, here the accident took place on 31/12/2012.
31,
12/2012.
31, 12, 2012.
12. But the owner, the insured, he died before the date of accident. He died on 21/12/2012.
1, 12,
2012.
2012. Owner of the vehicle.
Vehicle.
Third.
Yes.
Yes.
Now the award was passed against that person.
But he is indemnified.
He is indemnified, but the thing is, he was made a party before the learned tribunal. But
No, the liability is not been settled with him. See, the contract of insurance is also to cover assigned
Yes.
representative.
Yes.
So,
but the thing is, his legal heirs were not conceived.
understood. If the liability was passed upon the person who was dead, he legal heir comes, then matter would have been different. Now it's been casted upon. We'll clarify that.
And secondly, your lordship, the accident which I earlier said that took place on 31/12/2012.
Some death case here. Death case.
Yes, that case.
But due to, they are saying, the claimants are saying that due to the injury, he died on, succumbed to the injuries on 27/1/2014.
27,
1/2014.
2014.
Yes, that is after a period of about
1
1
year.
year, 1 month.
Yes. What had happened? What was the injury?
The injuries are mainly head injuries, and that has been reflected in the Exhibit 8. Exhibit 8 is the discharge certificate of the Dispur Hospital.
So
where he was admitted.
is your case that was not,
The death has
not
not
connected
occurred.
with the
Yes, yes. And there, your lordship will not find any document on record connecting the injury with the death.
that was the reason? What was the reason?
Reason of the death
How much
was,
is the amount?
amount is 5,63,401.
What was he doing?
He was a businessman. That has not been reflected also. Yes, as per the claim petition, he was doing some business. And the income was taken as 4,500 per month.
4,500.
Yes, as an unskilled labor. Now, the Exhibit 6, that will be relevant.
Was this your point that he did not die out the accident?
Yes, yes, we have taken that
Where?
in the WS.
Where? And how is it dealt with? How dealt?
Finding, your lordship will find at page number 4, page number 10, last para.
Internal page?
Internal page 4.
4.
Yes. Last para, Exhibit 6. Is a certificate given by the doctor of Sirakuti PhD. On perusal of Exhibit 6, it is found that the deceased Surman Wali was under his continuous treatment till his death. Exhibit 17 is a MDCT scan of brain of deceased Surman Ali, which has been done on 38/2013 at Dispur Hospital, Guwahati, about 5 months back from his death. The MDCT scan of brain of deceased Surman Ali reveals as follows: small focal area.
Where is your object?
My WS.
No, in the does
No, there we did not adduce any evidence.
no the judgment has it reflected? It been reflected there was
No.
veracity of
No,
the
that has
claim.
not been reflected.
Veracity
WS, your lordship will find it in the LCR. Paragraph 19 we have stated.
19.
Yes.
Right? It's spread there.
Yes.
What regarding his death, what was the due?
The
Evidence?
the doctor, he exhibited one certificate. He was under continuous treatment under that doctor.
His death
Not the death certificate. The Exhibit 6, that is a certificate by the doctor. Your lordship will find it in the LCR at page 42. Certificate is dated 3/2/2014. Last line, your lordship message on 27/1/2014.
You have the injury report.
Injury report, I don't have, but the discharge certificate that displays the injury. 8-1 and 8-2. Page 46, your lordship will find.
When was the
30,
31/12?
yes, 31/12, 2012. Another thing your lordship will see.
The in page 2,
Yes.
the history of patient is fall from bed
Yes, fall from bed on
on
12/1.
12/1/13.
Yes. And at the time of discharge, it shows to be his condition,
Improved.
yes, improved. And the medical prescriptions, your lordship will find only up to 38/2013. Thereafter, for a period of 5 months, your lordship will not find any medical prescription.
When was the history of fall
Pardon?
from bed? 12/1/13.
Yes, 12/1/13, fall from bed. And that Exhibit 6 certificate, that also says,
Okay. You have the evidence.
Evidence, I have the evidence, but the cross-examination is very.
You have
The opinion of the doctor is very clear, my lord. Cause of death is due to cardiopulmonary error.
no, that's okay, but 31/12/2012 was the accident.
Yes.
And same day he was brought to.
Yes. No,
And
first
he
he
had
was taken to Goalpara.
understood.
Yes,
But there is a document of dispute.
Yes.
Of having an operation on 31/1/2013.
31 1. Yes.
So that is proximate. If ultimately he passes, he died out of some other heart
Heart
failure. But if it can connect it to this, then we'll have a different view. But if it is not at all connected, just have a look at the. But we initially found, we thought that there was something, but it appears to be that there are documents support of the claim. It's not that it's totally unconnected. Continue.
Exhibit 8.2, where the operation was done. But that was done on 31/13. Thereafter, your lordship will find the prescriptions are only up to 38/2013. Thereafter, no documents. After the operation, he was discharged on 7/2/2013.
Yeah, on 12/1/2013, while narrating the history, it has been said that he fell from the bed.
Yes. The earlier discharge.
But from 31/12/2013,
yes,
2012,
yes,
to 31/1/2013, there is no. It can be said to be approximate only. Within 1 month, the operation was done. And there are documents to the history of road traffic.
No, that we have admitted that due to the road traffic accident, there might have been some injury, and due to those injuries, he has undergone treatment. But
So where is the first report of the injury? We're trying to have that.
Report. It might be Exhibit 5. It was issued by this Goalpara Civil Hospital. 31 dated 31/12/2012.
Date of the accident.
Date of the accident.
Exhibit 5.
Exhibit 5. That is not a certificate, but it is a prescription.
Five is the yes. Lacerated injury in left hand.
Yes.
Laceration of the left foot. Nasal bleeding and tenderness in nose. Patient was unconscious and disoriented at the time of admission.
So it is apparent that there was a
primary treatment was given and resurrection done. Patient referred to CMC for further evaluation of injuries. Suspected head injury, which is distant.
After that, he was admitted in the Dispur hospital.
Regarding the calculation, you don't have any.
Calculation, I don't have any issue, but this calculation has been made for the death. For the death. And the injury, for the injury, the calculation should have been something else.
We'll also have
Regarding
death. Yes, you're appealing for the claimant. But
Claimant. There is no any wrong in with the order.
let me understand why are you saying so? How do you justify? That accident was on 31/12/2012. The death was on 27/1/2014. After more than a year. How do you link the accident and the death?
After that treatment, is going
What-
on.
what was the
not
need?
only admitted.
What was the nature of injuries? What injuries did you suffer? Did the deceased suffer at the time of accident? Tell us. See, you have to link the fact of death on 27/1/2014 with the accident which occurred on 31/12/2012. It's your the onus is upon you. You have to discharge that onus. How do you what is your submission? What was the nature of injuries? What treatment did you take?
After the accident matter, he was admitted in Golpara.
Golpara. What were the injuries? Cause of that is something else. What was the cause of that, Mr. Doctor?
cardiopulmonary.
Cardiopulmonary failure. So you have to link the cause of death with the accident. Yes, death may happen after a year if it is directly related to the accident. But it's your onus to show that the accident had caused the death, which ultimately was after a year. But as you know, the date of death is not proximate, more than a year. So obviously the burden is on a higher pedestal.
And you know, they ought to have produced the evidence of a doctor also, an expert, who could have substantiated the injury. And
That
say
there was no improvement.
yes.
In the 1 year period, though he was treated,
And
he was
due to
deteriorated.
the injuries suffered on so and so, he died. And exactly on this point, I have one decision passed by this honorable court.
No, first let us finish his submission. Yes, what do you say? What is your name? What's your name?
Arif.
Islam. Yes, Mr. Islam, what say?
At this system, 2 weeks time may be given, matter. I will take the instruction from her.
17 matter, why should we grant you time? What instructions? There is no new instruction required. You need to make your submission. Come up for hearing 17 matter.
Yes.
Come day after tomorrow.
Yes.
Come prepared with this, not?
Yes. Yes. Very
We'll have it day after tomorrow.
Yes.
Okay. Sir, where is your colleague, Sir Ganguly? Other side? Madam? Oh yeah, he's there. You show the decision also on the next.
Lord, Lord, section 6, my Lord, Lordships had observed that there is no appeal. So, with the fact that, my Lord, there is no appeal, and the only remedy is revision. My Lord, jurisdiction is limited, no reappreciation of evidence as it would happen in an appeal, my Lord. So, the issue now is of jurisdictional, my Lord, whether the court below had jurisdiction. My Lord, the jurisdiction under section 6, as your Lordships are aware, my Lord, be that there has to be possession at a particular date. It may not be the true owner. The question of title is irrelevant, my lord. And the only fact that there are two aspects. One is the possession, and the second is the act of dispossession on a particular date. And the suit has to be filed within 6 months of the act of dispossession. On the second aspect, my lord, that the suit has to be filed within 6 months of the act of dispossession. Here in this case, my lord, the suit has been filed within 6 months of the alleged act of dispossession. But whether he was in possession, my lord, that is my main argument. If your lordship will kindly have the impugned order passed by the trial court, my lord, but it commences at page 25. 25, my lord, annexure 5. But issues 1 to 4, my lord, are not so relevant.
You're a defendant.
I am the defendant in this suit. Respondent is the plaintiff.
By page?
At page 25, it starts, my lord, the impugned judgment, dated 8th of July, 2019. Lordship, sir.
Dated 8th July.
8th of July 2019. The suit was of 2012. Now, issue numbers 1 to 4, my lords, are not relevant in the present context. I would take your lordship straight to, my lord, issue number 5, which starts at page, my lord, 32.
Page 32.
Yes.
Issues.
Issues. The findings on the issue.
No, issues are at 29.
Yes. Issues are at 29. And the findings, my lord, issue number 1 to 4, my lord, we are not.
5 is relevant.
Not relevant, my lord, in the present context.
No, which is relevant? 5.
No, that's 5. 5 and 6, 5, 6, and 8. I'll read, my lord, start from issue number 5.
Yes. 5 is whether,
yes, whether the suit line was possessed by the plaintiff till 20th of June 2012. Because the alleged act of dispossession, lordships will recall, is on 21st of June, 21/06/2012. So he has to show that till 20th of June he had possession. So this is a very relevant issue. Now, if I may read more. The land over which
we are reading at page 30.
32 months.
Issue number 5.
Issue number 5.
Okay.
The land over which the plaintiff has claimed recovery of possession falls under DAG number 223 and Tauzi number 97, Mouza so and so, measuring 2 kattas, 10 lichas of land, out of 1 viga, 1 katta and 13 licha land. As per the claim of the plaintiff, the said 2 katta, 10 lichas of land, that is the suit land, have been in possession of the plaintiff since long. Lordship will kindly mark this part. Have been in the possession of the plaintiff since long. There is no date to when he has come into possession, because this is Tauzi land, not inherited, not a patta land.
Yes.
The suit land have been in the possession of the plaintiff since long, and on 21/6/2012, the defendant dispossessed the plaintiff from the suit land. The plaintiff in his support adduced the evidences of himself as PW1, PW3, PW4, and PW5. All the PWs have deposed that the plaintiff has been in possession of the suit land, and the PW3 has seen the plaintiff possessing the suit land since 5 years, as the PW3 himself started residing in the said area since 5 years. The PW4 deposed that he was asked by the plaintiff to fill earth on the land of the plaintiff, and he further deposed that the said land falls on the eastern side of the NH52 and is attached to the said highway. The PW5, who deposed that he has often seen the plaintiff in possession of the suit land when he visits the house of his brother so-and-so, who has been residing in the area near to the suit land since 5 years. Section 60 of the Evidence Act provides that oral evidence must in all cases be direct. That is to say, if it refers to a fact which could be seen, it must be the evidence of a witness who says he saw it. If it refers to a fact which could be heard, it must be the evidence of a witness who says he heard it, and so on. Possession by a person is a fact which can be seen, and so under Section 60 of the Evidence Act, such fact of possession has to be invariably proved by oral evidence by such a witness who has seen a person to be in possession. In the present suit, the plaintiff claims that he was in possession of the suit land, and the same has been supported by the witnesses who have seen the plaintiff to be in possession. On the other hand, the defendant witnesses have deposed the fact that they have seen the defendants possessing the suit land, and in their cross-examination, they have admitted the fact that according to them, the suit land falls under annual Kheraj Patta number so-and-so and Dag number 225 and 226, measuring 3 kathas. As such, all the defendant witnesses have deposed the possession of the defendant number 1 over the above-mentioned land, whereas the suit land falls under Dag number 23 and 223 and Tawzi number 97, Mauza so-and-so, Borimudi map, measuring 2 katha, 10 luchas of land out of 1 biga, 1 katha, and 13 lucha land. The DWs have also deposed that other than the land mentioned by them in their evidence, they have not seen the defendants possessing any other land. Hence, considering the evidences of the plaintiff who have supported the fact of possession of the suit land by the plaintiff, and all that has been discussed above, it can be held that the suit land was possessed by the plaintiff till 20/06/2012. Hence, the issue number 5 is decided in positive. So, on the basis of the evidence that has been recounted here, it was held that he is in possession of the suit land till 20th of June. Now, issue number 6. Whether the defendants dispossessed the plaintiff by encroaching upon the suit land on 21/06/2012. As it has been decided in issue number so-and-so that the plaintiff has been in possession of it should be issue number 5, as it has been decided in issue number 5 that the plaintiff has been in possession of the suit land till 20th of June 2012. Now it has to be decided whether the plaintiff was dispossessed on 21st of June 2012. The plaintiff claimed that he was dispossessed on 21st of June 2012, and when the plaintiff asked them to refrain from such acts, the defendants remained away from such dispossession. However, in the month of October, they posted pillars on the suit land and thereafter constructed a room after receiving legal notice from the plaintiff. According to the plaintiff, he filled earth on the suit land and planned to construct a temporary house on the suit land, but he could not do so due to dispossession by the defendants. The PW3 and PW5 stated in their evidence that the plaintiff, for constructing a temporary house on the suit land, filled the land with earth, but in the middle of last year, as can be known from the evidence, it was recorded on 16/9/2013 and last year will be 2012. The defendant dispossessed the plaintiff. The PW4, who was engaged by the plaintiff to throw earth on the suit land, stated that he threw earth on the suit land in the month of November 2011, as the plaintiff wanted to construct a house on the suit land, and as per his knowledge, the land on which he threw earth belongs to the plaintiffs. The defendants could not derail the fact that they dispossessed the plaintiff either by cross-examining the PWs or by adducing their evidences. Although they denied the fact of dispossession, but the same is not sufficient to rebut the evidence of the plaintiff. The fact of dispossession is sufficiently proved by the plaintiff by oral evidences, and as such, it can be held that the defendants dispossessed the plaintiff by encroaching upon the suit land on 21/06/2012. Hence, issue number 6 is decided in favor in positive. Now, the issue number 7. Issue number 7, whether the plaintiff is paying Tawzi revenue. This is not so important. I'll go to issue number 8. Next page, whether the plaintiff is entitled to recovery of possession of the suit. As can be known from the above issues that the plaintiff has been in possession of the suit land prior to his dispossession by the defendants. Adding to this, the plaintiff has also submitted as Exhibit 4.1 the Jamabandi copy of the suit land bearing Patta number 97, wherein the name of the plaintiff is present as the Pattadar of the suit land. The defendants have objected to the said Jamabandi copy, stating that there is no signature of the circle office in the said exhibit, as well as there is no certificate as to when the exhibit 4 began or started and that there is no entry in the remarks column in the said exhibit. The plaintiff has also exhibited as exhibit 5.1 the chitta of the suit land, and the defendants objected to the said chitta, stating that there is no name of the plaintiff in the chitta. The defendants have also objected to the exhibit 5 by stating that without entry in the chitta, how can the name of the plaintiff be present in the Jamabandi? Although the Jamabandi does not have any entry in the remarks column or the signature of the circle officer, and that the chitta does not have the name of the plaintiff in it, nevertheless, the presence of the name of the plaintiff in the Jamabandi cannot be ignored, Jamabandi being the document of possession. The plaintiff, by adducing sufficient evidence to the fact that he has been in possession of the suit land prior to his dispossession, and by submitting the Jamabandi copy, has proved that the principle of preponderance of probability lies in his favor. And moreover, the defendants have completely failed to derail the evidence of the plaintiff. Hence, considering all the above, it can be held that the plaintiff is entitled to the suit land as he has been dispossessed by the defendants without due process or course of law. Well, the issue number 8 was on the documents, and 5 and 6 were on the oral evidence. So the oral evidences, the court held that the witnesses of the plaintiff have proved that he was in possession of the land prior to 21/6. And the documents, my lord, the date is not mentioned, but the court says that his name is in the document. So, my lord, let us see what the document is, my lord. If your lordship will kindly have, my lord, the exhibits. The exhibit 4.1 is the Jamabandi.
Yes.
Lord, maybe kept in mind, my lord, that the date of disposition is 21st of June 2012.
Yep. Which one?
My lord, exhibit 4, my lord, the Jamabandi.
Repeat.
4.
4.
Yeah, the Jamabandi, my lord, closing number 97. Your lordship will find, my lord, that there is only one date which is mentioned here, that is 28/4/14. Signature of Lat Mandal appears to be here. And it was exhibited, my lords. Date of the exhibit is also same. There is no other date, my lord. This document was filed. And
Just
yeah. And as we had submitted, my lord, that there is no signature of the circle officer. Only the Lat Mandal's name appears here. And that too in 2014.
When was it issued?
No, that they have to say because it appears to have been issued in
If it
2014.
is 28/4/14, when, how come it's exhibited on same date?
That is their document will be up to them to say. Because there is no signature, as we had objected then also, that there is no signature of the circle officer. And only the Lat Mandal signature appears to be here. And the date is also 28, there is overwriting on the date also. 28/4/14.
Was this person Ratmandal produced as witness?
Yes, he was produced.
Niran
Niren Bhuyan, yes.
Bhaiya was exhibited.
Yes, PW5.
Let us see his cross-examination. Number 5.
Yes.
Five is Sandeep. 4 is Robin.
10 p.m.
5 is
PW5 is hidden behind.
more naam is Sandeep. PW. Should be, I think, 4.
4 to 9. Sanjeev Gogoi is 4 years.
Robin should have been 38. He has been written.
Tanku Bhuyan is also, he is Muzadar.
Yeah, 6
He-
is
he
the
has also-
Muzadar. 6.
6 is the Muzadar.
6 is the
Uh,
Muzadar.
He is the Siddhanku.
There's some mistake in mark.
Yes, that's why it's written.
Hidden. Hidden here.
Hiren Bhuyan. Yes.
He did not give chief examination.
No, I think he was called as an official witness
Or as an
also, to prove.
Not on affidavit.
Not on affidavit.
No, affidavit is on. No, affidavit is specific. He has submitted or not?
It is.
Siddhanku Bhuyan is, but he didn't say.
I don't.
Yes, I have.
Huh?
Yes.
Hidden, did he give any?
Yes, he gave money. He was
gave or no?
PW5 according to the
In my certified copy, it's PW5.
No, 5. Did he give any chief on affidavit? No, I don't.
No, no, he's an
No, he is,
official-
no, he is
Not on
not
affidavit.
not on it.
not an
He is,
affidavit.
he has given,
Officially.
he officially appeared
That
and
is it. Mr. Ganguly was right.
Yeah.
Where is the cross-examination?
Cross-examination, my lord.
Not done.
Yes, it is done.
done, your
Done.
lordship will find. Cross examine.
It is there, my lord.
মই ইংৰাজী 2010 চনৰ পৰা লাট মণ্ডল হিচাপে আছো। I think that চালে তোমাৰ সেইখনে আছে না?
নাই, একো নাই। মই আজি
নাই, সেইটোতো
অকাৰী মৌজা
Where is this cross?
মই ইংৰাজী 2010 চনৰ পৰা লাট মণ্ডল
2010 চনৰ পৰা লাট মণ্ডল
হিচাপে আছো।
হিচাপে আছো।
That is the
এলেকা।
cross.
নথি উক্ত এলেকাৰ নথিবোৰ লৰ্ডশ্বিপ have it or it's on the second page.
Second page,
Second page,
last part.
last para.
Oh, yes.
After some
Yes,
cross.
Yes, 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 that part. মই ইংৰাজী 2010 চনৰ পৰা লাট মণ্ডল হিচাপে this part, my lord, I may point out.
What
Exhibit-
was that exhibit? Number 4.
Yes, exhibit 4-1 শান্তনু শৰ্মা বৰুৱাৰ নাম কেতিয়া অন্তৰ্ভুক্ত হল উল্লেখ নাই। This part. In exhibit 4-1 2 কটা 10 লেচা শান্তনু শৰ্মা বৰুৱাৰ নামে দেখা যায়। দাগ নাম্বাৰ 223 কিন্তু দাগৰ বাকী জমিৰ স্বামীৰ কথা উল্লেখ দেখা নাযায়। Because this 2 kata 10 lesa is part of 1 bigha, it's the entire dag. So the dispute is only that 2 kata 10 lesa.
Parties and exhibit 4.
Yes,
Exhibit are
number market.
How do you explain the date? How do you explain the date?
I'll come to that. So let him complete because just because of this, I will not further my argument on. Let him complete that part. Lord, kindly see to it.
No, the immediate reaction.
Yes.
This was not necessary even when ordered. This is a matter under section 6.
6. That is what
So-
I want to point out. My learned friend
Even
started this.
document perhaps would not have been necessary. But
Yes.
Not
What I would
it
like,
appears that
Had there been only the oral evidence.
what
had
I am
been
trying
only
to
the-
point out, your lordship, my learned friend, when he started his argument, the first line he said that the only thing under section 6 is with regard to possession.
Yes.
It's nothing to do with title. These are brought in just, I don't know, it should not have been brought. Anyway, the title is not important. Possession is important.
I'm not
And
claiming
from
that.
the evidences, there are,
we have noticed that he comes to the witness box on a particular date.
Yes.
And that certificate is also of that.
that
Not certificate, it's a Zamaband.
Jamaband.
is Zamabandi,
Certificate is also different matter. Yes, I have given.
And the circle officer's signature is not there.
it is not.
It is not. It is not a
Wait, wait,
computerized. printout.
that is, I don't know, at that point of time,
Okay.
Yes.
let him complete.
Similar, at the bottom of that very page, exhibit 5-1 শান্তনু শৰ্মা বৰুৱাৰ নাম দেখা নাযায় দুটা মন্তব্যতে। দুটা মন্তব্যত exhibit 5-1 the handwriting is তাৰিখ নাই 10/3/2005 আৰু ইংৰাজী 1/3/2005 exhibit 5-1 entry মন্তব্যত entry exhibit 4-1 নাই exhibit 5 দাগ number 224 দাগ নাম্বার 223 এন্ট্রি মন্তব্য ইংরাজি 13/9/2011 তারিখে দেখা যায়।
মন্তব্য ইংরাজি 13/9/13 তারিখে ছপা দেখা যায়।
Yes.
Exhibit নম্বর ডাগর চিঠির
পশ্চিমী দাগ নাম্বার 226 227 দেখা যায়। বাদীর এন্ট্রি এক্সিবিট 4 এতিয়া
এতিয়া
তাৰ
তাৰ
বিষয়ে উল্লেখ নাই, ক'ব নোৱাৰিম। So he could not say when that document was issued at all. Now, if your lordship will kindly come to the next document, my lord, that is exhibit 5. It is the chitta. 5. The chitta. Because one of our objections to these documents was that without including the name of the chitta based on the field index, the name was suddenly found in the Jamabandi one fine day. And the chitta, my lords, reflects that the name of the respondent, the plaintiff, my lords, was not there.
name of the plaintiff was not there.
Was not there. It was not there.
Who had exhibited Chitta?
He had all his documents. Exhibit 5.
Okay.
And this, my lord, if your lordship, just to have an idea of how the land is, my lord, lordship will come to the next document, you know, that is exhibit 7. That is the trace map. Just to give an idea, my lord, as to how the case is a little unique, my lord, in that sense. You know, this line, this road is the National Highway 52, my lord.
7 is the
7 is the Tauzi map. And 6 is the
trace map.
Trace map. 6, my lord, trace map, lordship will kindly see that this is the highway, my lord, that is going by. Now we are concerned only with 223, my lord. Only part of 223, not the entire 223. But let us assume that we are only concerned with 223, my lord, at the moment. Now with 223, lordships will find there are two other, my lord, dag numbers, that is 225, 226. Why these are relevant, my lord, I will say, because as on this date also, admittedly, these are in my possession. And he admits that. 225, 226 are in my possession.
Yes.
So, my lord, the defense of the petitioner was that we purchased 225, 226 from the father of the plaintiff. There is a kacha sale deed which was also exhibited. There is a story behind this. 225, 226 we purchased from him.
You purchased?
We purchased. There is a kacha sale deed that we exhibited.
Purchased from whom?
From the father of the plaintiff. And in order to go to 225, 226, we have to pass from the highway through 226. This was like an easementary access.
Through 223?
Yes, to go through 223. So this sale deed we exhibited, my lord, and your lordship will find that this sale deed, I have annexed with the petition also. It is there, my lord. At page 15 onward.
Will it exhibited?
Yes, exhibited.
As?
Sorry. My lord, this is exhibit 4. SMS 4. You know, the vernacular is at page 15B onwards, and this deed was executed, my lord, by Investor Sarma Burua, who happens to be none other than the father of the plaintiff. Now, this was in regarding to 225, 226, but my lord, if I may just point out for a minute, lordship will come to, my lord, page number 18
Of?
of the revision. I have annexed, where I have annexed the sale deed. Yes, my lord, lordship will find the circle part. Then this plaintiff, my lord, was a witness to that sale deed. The circle is there, my lord. Shantanu Sharma Babu.
Yes.
He was the witness number 2. His brother Kamal Sharma Barua was the witness number 1. And at 2 places his signature is there.
Now, what do you intend to?
Now, if I may further point out only the boundary, the schedule.
Yes.
The lordship will find in the topsil this Purbe Sarkari Mati O 52 number Rastriya Haikot. So this Sarkari Mati is none other than this 223. It is not described as Niz Mati, but Niz Dokhal Thaka Mati. Nothing like that. And this was done in 1994 by the father of the plaintiff. And since 1994, in order to go to Dag number 225 and 226, I have to pass by this Joldova land, which is none other than 223. In fact, my lord, the conduct of the plaintiff is such, he denied this signature, he denied this sale deed. Whatever, it may be a kacha sale deed, whatever. He has denied his signatures. Matter was sent to FSL, my lord. FSL report came in our favor. So in a case of specific relief, my lord, under the ESR Act, my lord, the contract of he was a witness of this agreement.
Where did you
Yes, Purbe, Purbe,
East.
Sarkari Mati, east. As I have shown from the trace map, it is to the east. This Sutland is to the east of 225 to 26. It is not said that it is Niz Dokhal Thaka Mati or anything like that. It just said Sarkari Mati.
That was in which date?
Not,
12 to 94.
Yes, 12 to 1990.
But the date of disposition is somewhere in 2012.
Yes, that is his claim is not that we have disposition from 225 to 26. His claim is that we have disposition from 223. And our claim is that 223 was always in our possession. Because, my lord, 220 in order
No,
to go to,
what you are trying to hit up
Yes.
in this sale deed,
Yes.
which
he was
is in your favor, executed by the father of the plaintiff.
Yes.
It is pertaining to 2 plots of land, on the east side of which there is this particular
plot.
plot,
Yes.
along with the NH
NH
52.
and then NH 52.
52. You said that this plot of land has been described as Sarkari land.
Yes.
This was in the year 1994.
1990. Yes.
And from 1994 to 2012, long considerable period has elapsed.
Considerable period has elapsed.
Now, in that time, it cannot say that they are not in possession. Even if we take your case, at that time it was not in possession. After that, isn't it possible, or is it impossible rather?
No, yes. Now the fact of the matter
It is not proximate that just 2 months.
Yes, I absolutely bow down to what your lordship is saying. But, my lord, for that the plaintiff in his suit must mention a date, my lord, as to when he has come into possession. Can he say that I came into possession since long? What is that long, my lord? Can he say I came into possession
But
time?
there are witnesses who have said that from 5 years they have been seeing.
No, that is, they have seen him for 5 years.
5 years.
But
Nobody has
He-
said that prior to 1994 they were seen into 20.
No, 1994 would not be relevant as far as the date of disposition is concerned. My question is that, my lord, the deed of 1994
No,
makes up
not from date of position. From the date of position. Nobody has said that even prior to 1994 we have seen him, because 1994 he did not claim that his land was within his position.
He does not have to show that he was there in 1994. He only has to show that he was in settled position as on 20th of June 2012. That is the point.
There are two witnesses who have seen,
There are two witnesses who claim that they saw him on the land. My lord, the fact of the matter is, this is, as I said, Jaldoba land, and this land provides an easementary access to the 225 to 26. Now, in 1994, admittedly, my lord, it cannot be that this land was under their possession, but he has to at least say and show something that this land, my lord, somebody can see somebody in another person on somebody's land. No issue with that. But my lord, where is the proof of settled possession, my lord? It cannot be a stray act. Somebody comes and stands on land, my lord.
The witness has not seen that at times I have seen him.
Yes.
The witness has said that last 5 years I have seen him on that land.
Yes, that can be.
And his statement is not contradictory. He says that I have been staying here for long. He has not said that I was staying for just 1 year. Witness says, no, I've seen him for 5 years.
Yes.
Then my contradiction, there is no contradiction.
No, in the oral evidence, my lord, to that extent.
You are trying to say that he has not specified from which date.
From which date?
But he has said that I've been staying for long.
Yes, he has said
He
that
gets the support from PWs.
Yes.
One visits his relative and offense is him there, and the other says I am speaking.
My lord, if he is in possession prior to 20th of June, why each and every document is from October 2012, my lord? Why he paid revenue in 2012? My lord, the burden lies upon him to show that he was he was there. Anybody can go to a particular piece of land or try to occupy a piece of land. Now the earth filling is there. Earth filling, he said somebody, my lord, anybody can go and try to occupy because this is a government land. It's like a free for all, my lord. So he may have tried to occupy the land, but whether he was in
From
settled possession.
2012, the documentary evidence, that part, I do not know what advice was given, but it has rather damaged this case. But we cannot at the same time ignore the oral evidence.
Well,
more so when we are dealing with a Section 6 application.
Yeah.
Suit under Section 6.
But my lord, the oral evidence cannot be, my lord, contrary to what the document.
If the law says that 6 is only for the purpose of taking into consideration the possession, nothing to do with title.
Yes.
And I don't think that documents as such was necessary.
Yes, my lord. Now, all these documents were, my lord, after October 2012, when he started, my lord, planning for the case.
If we accept your argument, we ignore all the documents.
Good.
Yeah.
Look, the documents and the oral evidence, my lord, cannot be contrary to each other.
These are not contrary.
So they are, my lord, because the witness is saying, I am seeing him for 5 years.
Yes.
Has he produced a single document, my lord, to show that he was in paying revenue or that he was in possession of the land? The Jamabandi lordships have seen what is its value.
What revenue? Tawzi.
Tawzi
from where?
Tawzi has been paying after 2012, 2013 onward.
Where?
Yes, the receipts have also been exhibited. No? But exhibit 1 and exhibit 8. Yes. Exhibit 1 is 15/10/2012. This is the earliest in point of time.
15/1/10.
15/10/2012.
Exhibit 1.
Exhibit 1. No, 12.
12.
15 October 2012.
Exhibit 8 is 17/10/2013.
Yes, the other exhibits are all later in point of time. Exhibit 1 is the earliest.
Yes.
My lord, as on 20th of June 2012, there is nothing to show that he was in possession of that. My lord, witnesses can be there, but when the oral evidence shows, points to his being in possession of the land and the documentary evidence indicates otherwise, when there is a contradiction, my lord, the documents do not lie, my lord. Witnesses lie, documents do not lie. My lord. He was trying to be, my lord, manufacture a case where there was none. This is a Joldova land, a swampy land. And on this land, he has got witness. My lord, there may be defects in the cross-examination by the defense, the learned counsel for the defendant. No, we are not on that. Let us assume that he was seen on the land a couple of, or maybe many times. Would that make him even then, my lord, in settled possession? The law does not protect my lord.
Suppose in a given case, he is in possession, but he is not paying trustee.
Good.
Only because he is not paying a trustee. Can you say that he is not?
My lord, ordinarily, my lord, no. But in a case,
Somebody might have advised him that pay the trustee, it will raise some additional rights.
so then, my lord, let us see what the plaintiff's
Only
case is
because
all
he
about.
paid trustee, after that, can you say that
My lord,
it's
here,
contradicting?
my lord, the
No,
plaintiff,
because you are
plaintiff-
trying to make out a case that the documentary evidence is in conflict with the oral evidence.
It's because these are his own documents, my lord.
No,
He may
by
not have
paying
filed this.
trustee after the date,
Good.
will the oral evidence be obliterated?
No, it will not be obliterated, but it will have to be treated with utmost caution, my lord, because in light of the contradiction with the documentary
Not
evidence,
contradiction, maybe it's not supporting. Not
they are
contradiction.
not, they would not support.
Support.
Now, my lord, witnesses may have indicated that his presence is there on the suit. But what of, my lord, there could be any other claimant who could have also produced witnesses saying, no, my lord, the one important point is that the witnesses for the defendants, the petitioner, my lord, they did not say we have not seen him in there. They have said that we saw him on that number so and so. Not
On the other side.
on the other, no, my lord,
But
sometimes
they have not said that you have been seen in this dark.
the dark number is the problem. My lord. Sometimes, my lord, as
You
your
have
lordship
been
knows.
seen in some other dark.
Yes,
And
because
that are
my
different.
lord, these are adjoining darks. The trace map
Understood.
showed.
Why did they mention the dark?
That part, that is
You
a,
have never even asserted
that is the problem with the defendant's evidence, which has been relied upon. My lord, but let us see the case of the plaintiff. My lord. Plaintiff has no date when he
So
came
that
into possession.
we were to ask questions you are raising.
Good.
All your documents have, all your witnesses have said that you are seen to be in possession with two other dark.
Yes.
They have not never said that you are also in possession of this dark.
No, the dark number, my lord, they have wrongly said. They have said 225 to 26.
They
That much
should
I
have said
cannot.
that we have seen him in the suit pen.
Yes.
Why they are mentioning dark?
That I do not know, my lord, how the evidence has
They are
been
your,
recorded. That is
your
witnesses. My lord. That part
that
is
is
there.
something which is
But there are two aspects here, my lord, which he has to over. Three aspects rather. One is that, my lord, when and how he came into possession of this land. That is the first aspect. Because, my lord, the aspect of possession is here, no title is involved, only the aspect of possession has to be considered. Secondly, my lord, he has to show that he was in settled possession, not a casual or stray or fugitive possession. And thirdly, my lord, he has to show that regarding dispossession, my lord, there is absolutely nothing to show that he was dispossessed on a particular day. There is no complaint, no ejahar, nothing. My lord. Only the witness have said that yes, we have heard that he has been dispossessed. There is nothing apart from that. So the fact that he chose a particular date to say that yes, I was dispossessed on that date, he has to show evidence of dispossession. So there is nothing. Normally in these cases we have an ejahar or something like that. Now on the aspect of possession, my lord, I have one decision which I would like to rely upon.
yes.
Sure.
That is
This is the 2003 Supply 6 SCR. Supply 6 SCR, my lord, and page number would be 850.
Six.
Yes.
SCR
SCR
860
850.
850.
A very well-known judgment, from the aspect of possession. Now, I would keep your lordship to 856, page number 856.
Yes.
Lordship, no. This partner. It is thus clear that so far as the Indian law is concerned, the person in peaceful possession is entitled to retain his possession, and in order to protect such possession, he may even use reasonable force to keep out a trespasser. A rightful owner who has been wrongfully dispossessed of land may retake possession if he can do so peacefully and without the use of unreasonable force. If the trespasser is in settled possession of the property belonging to the rightful owner shall have to take recourse to law. He cannot take the law into his own hands and evict the trespasser or interfere with his possession. The law will come to the aid of a person in peaceful and settled possession by injuncting even a rightful owner from using force or taking law in his own hands, and also by restoring him in possession even from the rightful owner, of course subject to the law of limitation if the latter has dispossessed the prior possessor by use of force. In the absence of proof of better title, possession or prior peaceful settled possession is itself evidence of title. Law presumes the possession to go with the title unless rebutted. The owner of any property may prevent, even by using reasonable force, a trespasser from an attempted trespass when it is in the process of being committed or is of a flimsy character or recurring, intermittent, stray or casual in nature, or has just been committed, while the rightful owner did not have enough time to have recourse to law. In the last of the cases, the possession of the trespasser just entered into would not be called as one acquiesced by the true owner. It is the settled possession or effective possession of a person without title which would entitle him to protect his possession even as against the true owner. The concept of settled possession and the right of the possessor to protect his possession against the owner has come to be settled by a catena of decisions. The authorities need not be multiplied. In Munshi Ram so-and-so, it was held that no one, including the true owner, has a right to dispossess the trespasser by force if the trespasser is in settled possession of the land. And in such a case, unless he is evicted in the due course of law, he is entitled to defend his possession even against the rightful owner. But merely stray or even intermittent acts of trespass do not give such a right against the true owner. The possession which a trespasser is entitled to defend against the rightful owner must be settled possession extending over a sufficiently long period of time and acquiesced to by the true owner. A casual act of possession would not have the effect of interrupting the possession of the true owner. A rightful owner may re-enter and reinstate himself provided he does not use more force than is necessary. Such entry will be viewed only as resistance to an intrusion upon his possession which has never been lost. A stray act of trespass or a possession which has not matured into settled possession can be obstructed or removed by the true owner even by using necessary force. In Puran Singh's case, the court clarified that it is difficult to lay down any hard and fast rule as to when the possession of a trespasser can mature into settled possession. The settled possession must be effective, undisturbed, and to the knowledge of the owner or without any attempt at concealment by the trespasser. The phrase settled possession does not carry any special charm or magic in it, nor is it a ritualistic formula which can be confined in a straitjacket. An occupation of the property by a person as an agent or a servant acting at the instance of the owner will not amount to actual physical possession. The court laid down the following tests, which may be adopted as a working rule for determining the attributes of settled possession. One, that the trespasser must be in actual physical possession of the property over a sufficiently long period. Two, that the possession must be to the knowledge, either express or implied, of the owner or without any attempt at concealment by the trespasser, and which contains an element of animus possidendi. The nature of the possession of the trespasser would, however, be a matter to be decided on the facts and circumstances of each case. The process of dispossession of the true owner by the trespasser must be complete and final and must be acquiesced to by the true owner, and that one of the usual tests to determine the quality of settled possession in the case of culturable land would be whether or not the trespasser, after having taken possession, had grown any crop. If the crop had been grown by the trespasser, then even the true owner has no right to destroy the crop by the trespasser and take his forcible possession. In the cases of Munshi Ram and so, wherein a distinction was drawn between the trespasser in the process of acquiring possession and the trespasser who had already accomplished or completed his possession, wherein the true owner may have treated to have acquiesced in, while the former can be obstructed and turned out by the true owner, even by using reasonable force. The latter may be dispossessed by the true owner only by having recourse to the due process of law for reacquiring possession over his property. So, my lord, it has to be settled possession, my lord. It has to be proved not only by, my lord, calling of only witnesses who claim to have seen, because there is nothing, there is no structure erected by him on the land, nothing has been constructed by him, and he did not pay revenue until after, much after the alleged act of disposition. So in such circumstances, my lord, it was incumbent upon him not only because, my lord, even if an oral evidence is there that a person is seen on a particular land, unless he does something, unless he shows his animus, my lord, to project himself as the owner of the land. The allegation against me is that I was erecting a room on the land, erecting pillars. I have shown my animus, my lord, that I was in control of the land on a particular date. But what is the animus shown till 20th of June 2012? My lord? Absolutely nothing, my lord, apart from being allegedly seen on the land. My lord, in such circumstances, the plaintiff is free to file, as I was suggesting, my lord, that the plaintiff was free to file a proper suit if he was in and prove his title accordingly. But he has not shown, my lord, irrespective of the question of title, he has not shown any element of possession, any act showing his animus, my lord, on 20th of June 2012. My lord, the entire story is a concocted one, and my lord, he is a trespasser.
Let me read. Since my learned friend has already read the judgment, I'm not going to read the judgment. But I will just take your lordship to the defendant witness, the main defendant witness. The petitioner here is Arvind. Just read that one. Defendant witness number 1, Podumi Deuri. This is the your lordship revision petition. Revision petition. Podumi Deuri, DW1.
Page.
No, this is not annexed. Your
No, you said it's a revision.
DW1.
You said it is a revision.
No, not review. She is the
Oh, that-
review revision petition. Record, your lordship will kindly take up DW1. PW1 lordship he has already read.
Yes.
DW1 Podumi exhibit 4. It starts from exhibit 4. Yes.
Yes.
Exhibit 4 যোগে শ্ৰী ডিম্বেশ্বৰ শৰ্মা, ইটা মৃত দিবাকৰ শৰ্মাই মোক 60 নম্বৰ একচনা পট্টাৰ 3 বিঘা মাটিৰ দখল সমঝাই দিয়ে বুলি এক্সিবিট কত লিখা আছে। এই 3 বিঘা মাটিৰ উত্তৰে সয়ঞ্চ, দক্ষিণে সয়ঞ্চ, পূবে সয়ঞ্চ, পশ্চিমে। That already he has shown. Now, প্ৰদৰ্শক ক মই কিনি লোৱা একচনা পট্টাৰ 3 বিঘা মাটিৰ বাদে ওচৰৰ কোনো চৰকাৰী মাটিৰ দখল সমঝাই দিয়া কথা উল্লেখ নাই। মই দখল কৰা প্ৰদৰ্শক গ ঘ উঙ একচনা পট্টাৰ 3 বিঘা মাটিৰ খাজানা দিয়া ৰচিদ। এই 3 বিঘা একচনা পট্টাৰ মাটি কিনাৰ পিছত উত্তৰ লখিমপুৰ চাৰ্কল অফিচত মই এটা এনআৰ কেছ দিছিলোঁ। কেছ নাম্বাৰ 6 উত্তৰ এনআৰ গোচৰত মোৰ এই হয় আজি এই গোচৰ অহা মোৰ এক সাক্ষী সীতাৰাম বৰা নৰেন চয়েন্স দিয়া এনআৰ গোচৰ 2 কিমানটো মোৰ হয় সাক্ষী দিছে। এই গোচৰ কৰা আগতে বাদী শান্তানু শৰ্মা বৰুৱাই মোলৈ মাটিৰ সন্দৰ্ভত উকিলৰ দ্বাৰা নোটিছ পঠোৱা কথাটো সত্য নহয়। এক্সিবিট 2 ডাক যোগে মোলৈ পঠোৱা নোটিছ, এই নোটিছখন মোৰ হয় মোৰ ভাৰতীয়াই ৰিচিভ কৰিছে। নাও দ্য ইম্পৰ্টেণ্ট পাৰ্ট, যি মাটি সন্দৰ্ভত বাদীয়ে মোৰ আৰু মোৰ ল'ৰাৰ ওপৰত গোচৰ কৰিছে, এই মাটি ডাক নম্বৰ মই ক'ব নোৱাৰিম। কিমান মাটিৰ ওপৰত এই গোচৰ কৰিছে মই ক'ব নোৱাৰিম। মই 1994 চনৰ প্ৰদৰ্শক কৰা যোগে কিনি লোৱা একচনা পট্টাৰ 3 বিঘা মাটিত কিনা দিনৰ পৰাই সীতাৰাম বৰা আৰু নৰেন দৰাই খেতি কৰাই আছো। প্ৰদৰ্শক খন মোৰ স্বামীয়ে সকলোবোৰ তৰণীৰ দ্বাৰা তৈয়াৰ কৰিছিল। সেয়ে মই প্ৰদৰ্শক কৰ বিষয়ে ভালদৰে নাজানো। প্ৰদৰ্শক ক উল্লেখ কৰা 3 বিঘা মাটিৰ পূব সীমাত থকা দাগ নম্বৰ বা কালিৰ বিষয়ে মই নাজানো। মোৰ 3 বিঘা মাটিৰ ওচৰত চৰকাৰী মাটি আছিলে বুলি মই জনা নাছিলো আৰু মই কিনি লোৱা 3 বিঘা একচনা পট্টাৰ মাটি পকা খুটা পুতি প্লিন্থৰ লৈ বনাইছিল। বৰ্তমান উত্তৰ 6 চনত কিনি লোৱা 3 বিঘা একচনা পট্টাৰ মাটিৰ ওপৰতেই মোৰ দখল আছে। এই মাটিৰ ওচৰৰ পাজৰে থকা অন্য মাটিও মোৰ দখল নাই। সত্য নহয় যে আমাৰ একচনা পটাৰ ওচৰত থকা বাদী দখলৰ গুচৰীভুক্ত মাটি ইমান তাৰিখে বলপূৰ্বক বেদখল কৰোঁ। সত্য নহয় যে ইমান চনৰ অক্টোবৰ মাহত মই ঘৰ বনাবলৈ পকা খুঁটা পুতো। সত্য নহয় যে বাদীয়ে অধিবক্তাৰ যোগেদি মোলৈ নটিচ পঠোৱাৰ পাছত মই গুচৰীভুক্ত মাটি মই আগতে পুতি থোৱা পকা খুঁটা প্লিণ্টৰলৈকে বনাওঁ। মই উল্লেখ কৰা মোৰ পত্ৰ শপতযোগে সাক্ষাৎ গুচৰি জমিখিনি 225 আৰু 226 নামৰ দাগৰ 30 নম্বৰ একচনা পটাৰ মাটিখিনিকে বুজাইছো। 30 নম্বৰ একচনা পটাৰ মাটিখিনিকে বাদীয়ে মোৰ পৰা লৈ ল'ব পাৰে বুলি মই ধাৰণা কৰিছো। সত্য নহয় যে মই মোৰ সাক্ষিত লিখা সকলোবোৰ কথা সত্য নহয়। সত্য নহয় যে বাদীৰ দেউতাকে আমাক সমজাই দিয়া 3 বিঘা একচনা পটাৰ মাটিৰ ওচৰতে থকা বাদীৰ দখল গুচৰি ভুক্তি মাটি আমি বেদখল কৰিছো। সত্য নহয় যে সেইবাবে বাদীয়ে এই গোচৰ তৰিবলৈ বাধ্য হৈছে। Now the question arises, my learned friend was all throughout saying that they were in possession of the land. The main petitioner, the revision petitioner says they were not in possession of any land except that 225, 226. 223, according to her, 223 is not in their possession. Now she has a feeling that we may evict them from that 225, 220. He says, he is the petitioner. I am coming before your lordship in the case of 223 specifically. And in that case, 5 persons, 6, 7 persons, 7 PWs have given their evidence in my favor. All the witnesses say that this person is in possession of this. Yes, the only thing that my learned friend pointed out, which are not actually required, but somehow these were all there, was with regard to the Jamabandi and the Sitha. The Jamabandi and the Sitha the Jamabandi has the name, but Sitha does not have my name. Officially, it should have been the circle officer who would have been in a better position to answer. But since that part is not a relevant part.
You just read out the position of the DW1.
DW1, who is the person concerned?
Party who had approached the court is your guy.
Yes, Mike.
Under section 6.
Yes.
You said that you were disposed.
I was in possession.
You were disposed. In their evidence, they have never said that they are in possession of their property.
Yes. Since
then, if they are not in possession, then where is your cultivate?
We were actually, when we came before your lord, by the filing the plain. Yes, plain. We came by filing a plain saying we are being disposed. We are being disposed. Then we gave our PW saying that we are in possession on particular date. We are disposed.
Correct.
Yes. So there is no dispute. They have also not challenged that it is actually not. These are on record. It is correct. All the PWs have said the same. Now the DW when came before the court and gave their evidence, they did not say that they have dispossessed. They said that we are not even in possession of it. If that is so, we are not dispossessed. Obviously, we should not have been dispossessed. That is why, if the order is given in my favor, what is wrong? We are given we say dispossessed. They say you are not dispossessed. That land, we don't even know that land exists. I am concerned with my land. I thought that you want to evict me from the 225 and 226. That is why I have come and said we are not in them. Now, what happens in that? The court will decide, yes, if you are not even holding that land, you are not in possession of the land, there is no dispute about my possession. That order could have been passed. Yes, he is in possession, let him be in possession. Because of the fact my learned friend has all throughout said we were in possession and we have constructed pillars in the land. That is a fact that has been admitted by my learned friend has submitted. We have also submitted in the PWs that he has tried to construct pillars. We have put, so we have filled up the land. After that, they constructed 2 pillars. On that ground, we came. And that my learned friend submitted. Yes, we have constructed, we are in possession. But that is absolutely contrary to what the DW has said. The DW said, that, no, we are not concerned with your land. It is your land. I am not in possession of your land. I am with 226. Then, if that is so, even the learned trial court should have considered this and pass an order saying that no, these are the person who is already in the land. They have not said that they are in possession of the land, so they don't have any right over it. Court has taken into consideration the fact that yes, you have put on 2 pillars, therefore you have dispossessed the person on particular. And it is not a fact that I have not said that I am not in possession. They cannot prove that I am not in possession. They tried to show that they were in possession. He made an argument before your lordship saying that actually we are in possession. But if that is so, this what happens to the DW? The main petitioner says that I am not in possession of the land. I don't know whose land is it. I have nothing to do with that. I am concerned with these 2 lands. In that case, what argument I will make? I have made that I am in possession. That your lordship has seen. Now they have said I am not in possession. I don't.
How do you make the argument of saying that you have not specified from what date you are in possession? And why you have made first is relying upon decision of the Honorable Supreme Court.
That is with regard to title.
Mega.
That is the case of a title.
Not title. That pre-position or interpreted position is not necessary. Just specifically, unless you are in settled position, you even against a person with absolute authority, the title even he may not have until he evict you by due process.
Yeah.
Now, how do you distinguish between the fact that you are in the allegation that you are a stray possessor, or stray possessor or interpreted possession and not to? It need to be a settled person. And you have not said your evidence that how long you have been.
Specific
Or-
date has not been specific date. I understand it has not been stated, but since this is a case under the specific relief act, we have to show that at that point of time, just before that point of time, that means on the day 21st is the day. So on 20th I should be. So it should be just a day before the dispossession part. So on that day I am in possession. And from the evidences, one thing is correct that for the last 5 years I am in. That is there. But though I have submitted documents to show that I have paid the, I think, revenue, this, my learned friend said that this is with regard to the subsequent part. The evidence of the revenue authority was also taken in, I think, PW 6. He said that
What
yes,
is the requirement of
section 6, your lordship will kindly take up then the, there are 3 things. There are specifically 3.
20%?
Hmm.
Without of otherwise then your
No suit under this section shall be brought after expiry of 6 months from the date of disposition. B, against the government. No appeal shall lie. This part is not required. Nothing in this section shall bar any person from suing to establish his title to such property and to recover possession thereof. These are the only part in this section 6. Section 6 does not say with regard to title, interest. I am in possession. If I come and it's a case of mine, I am the plaintiff. I said I am in possession and I am this. Somebody comes and says that no, I am nothing to do with the land. Then there is nothing. The case doesn't remain that. The case will come up when the other side would have come and said, yes, I am also in possession in this land since so and so, and I am not dispossessed. He has never been in the land. That was not the case. When we came and filed the case and we gave the PW evidence is given before the DW. The PW, we have shown that we are in possession of that. After that, the DW number, main DW number 1, who is the revision petitioner says that I have nothing to do with it. And she was saying about some other case with regard to that other part of land which was sold to them. There is no dispute with regard to the 3 bighas of land that was sold. And they don't even know which is the land the case is filed. And in what way they are saying that that is the reason. That itself is the reason they don't even know which land is what. And they must have encroached upon. This is the reason this case. And these 2 pillars that they are saying they have admitted, they have erected 2 pillars, but they say that in their own. But actually they didn't even know that that land is 223, not 225. That is
Now, what is the present position?
present position, Your Lordship, after the judgment of the trial court. They have come before the sound court and there's a stay order.
There's
So
an
it is,
interim
it is as it is.
Execution is
And there was, I think, a long period of adjournment taken by them.
I'm sorry, they were adjournment by both sides.
I have got the certified copies. I have come this time for the first time for the
You have come for the first time. Mr. Sattar was there.
So anyway, that is not the issue here. I am concerned that what the submissions were made by my learned does not tally with what has been stated in by the DW. He did not point out the DW. He did not read any of the DW. The DWs were nothing to do with. They only said we have put the pillars in our land. But when it came to the court, when we came to the court said no, you are in possession. So you dispossess them by putting those pillars. So now you cannot dispossess them. So that is there. They admit that that is not there. So nothing remains in this case. Now I don't have to prove my time.
This particular DAG is 223.
My case is under DAG 223. The application, Your Lordship, will find at page.
Yes.
That is at page, I think, 11. Specifically, Your Lordship will see that also is required to be seen once. Page 11 of the revision petition for a moment.
Okay, no. Just wanted to clarify. And you had purchased 225 and 226.
Yes.
Yes.
225 and 220.
Yes.
From his father.
Yes.
From his father,
Invest.
which is adjacent to the land and requires to be for my access.
Okay.
Now just to point.
Anything else?
Yes, just one more point. In my application, Your Lordship, I made 2-3 things specific. I have stated that 225, 226.
What document?
I'm from page 11 of the revision petition. This is my application under section 6 of the specific relief.
Page 11.
Page 11, annexure 1. Yes, here Your Lordship will see that paragraph 11, paragraph 4, that the land bearing DAG number which are in the name of the plaintiff's mother and
Paragraph
daughter is
4.
in possession of the defendant and taking advantage of the same, and also the fact that the house of the plaintiff is situated at a distance from the suit land, the defendant have been possessing the suit land after forcefully taking possession on strength. So they have stated it is an adjacent. After coming to know the same, the plaintiff asked the defendants to refrain from such act, and as such the defendant kept the land as it was at that time. But in the month of October of that year, the defendant posted concrete pillars. This is only on the suit land for construction house there. The plaintiff, due to such illegal activities, sent a legal notice dated 26/10/2012. That is admitted, but the postal department could not serve the said notice and it was returned to the plaintiff. Again, the plaintiff on so-and-so sent a notice to registered post to defendant number 1. The defendant number 1 received the notice on 25/11/2012. So second time it was received, and that the DW has admitted. So we would have sent a legal notice without there being something done in this land. Number 1. The second part, Your Lordship, I'll come to para 7. that prior to the disposition of the suit land, the defendant never had possession of the same. Only the plaintiff had continuous possession of the plaintiff by regular payment of revenue has maintained his right and title over the same. The plaintiff often used to look
I
after
think
the
this
para 7.
paragraph 4, if board should be, it should have been defendant.
Which one?
To read paragraph 4,
Yes.
first line.
Yes.
That as the dark numbers, the dark band bearing dark numbers are in the names of the plaintiff. or
Plain,
defendant.
no, it should have been the
Defendant.
defendant. It was in the defendant. Para 7, your lord.
Okay. Just a,
Prior to the disposition.
just a minute.
LP fund. There are
Huh?
four.
You have written body on.
No, Malad, this is correct translation.
Oh,
As the
correct,
land bearing,
body.
which are in the names of the plaintiff, name is still of his family only. Even after that, purchase LD, 225 to 26 name also is of
No, the conditions
plaintiff
are
on-
correct. If you come to page 11F.
Yes.
Badi,
It is
Aru, Badi,
it is correct, your lord.
Maru, Dadar.
Badi Ma Aru Dada Namak ka
Yes.
Ukto.
It is correct.
225 to 26 naman.
It is
So
still in
it
there.
is- It is still in their name. That is not
So
been-
that is also in the name, but he is not on that.
But the translation is also-
Yes, they translated it directly. That is why.
What is your
Though it is in the plaintiff. Now,
No, what is the-
second 7, your lord. 7, para 7. Page 11B. That prior to the disposition of the suit land, the defendant never had possession over the same. Only the plaintiff had continuous possession over the same. The plaintiff, by regular payment of revenue, has maintained his right and title over the same. The plaintiff often used to look after the said land, even though his house is situated at some distance from the same. As the suit land is a low-lying land, the plaintiff did some art filling in the month of November last year. The plaintiff wants to construct a temporary house over the said land by making it suitable for art filling after art filling. But the defendant, by dispossessing the plaintiff, have destroyed his plans and caused irreparable prejudice. This part then, the plaintiff was in occupation of 2 kotha 10 lesses of land out of 1 bigha, 1 kotha 13 lesses under 223 of Tozi number 97, and he was paying Tozi revenue to the government. Now, this is actually the fact that this is a part of 220. We are only 2 kotha 10 letters on the part of 220. Their land, now this, he has already explained that the land is on the other side. There is a highway. There is a land. They have their land 225, 220. Though it is in our name, my father has already sold it to them. So I have no claim on that. And I'm not claiming the case of it. My only claim is the 225, 220 given to you. You cannot come and take my 220. Since you are dispossessing by putting those pillars, I've come before the court. I have given my evidence, proof my that much, your lord. That's enough to show that I am in. Further, I don't even require to say anything. Then in the DW, they came and said, no, we are not in the possession of them. It is nothing. Once they say that, their claim automatically goes. And the court passed an order in my favor. Nothing is wrong with it. That's all, your lordship. I don't make order submissions of that's it.
Point if I may point out. As far as the defendant's evidence is concerned, Malay, the court has already recorded that there are some deficiencies in the evidence. And however, Malay, as far as defendant number, the DW1's evidence, the defendant has pointed out, now it cannot be both ways, Malay. If there is no possession, then there is no disposition. And if there is no act of disposition, then section 6 would never come into play. And the learned trial code has to have committed a jurisdictional error, because jurisdictional error would be.
In that case, why do you agree?
That is precisely the point, my lord.
No, if you are not being,
No,
if you are not
exactly,
being affected
now
by
the-
judgment.
Yes, now the issue is that
Right.
no, if they are aggrieved, if they are relying upon it.
No, we are adjudicating this which is for us.
Yes.
You are the revision petitioner.
Yes.
You are, we are obviously agree by a particular judgment.
No,
Yeah.
the revision petition is filed saying that they are in possession. That is what.
They
that
are
is what.
agreed by the
Yes.
judgment.
We are
If you
agreeing.
are not in possession of the land,
Yes.
let there be hundreds of judgments. If you are not affected, why do you
Exactly.
seek court?
That is the point, because that evidence cannot be relied on to say that there is no possession at all. If there is no possession, my lord, then there is no disposition also. There is no, when there is no possession, there cannot be any disposition by me. Because the fact remains that, my lord, only by a possession, a prior possession and a disposition, the twin elements have to be together. If no possession, then there is obviously no
No,
disposition.
DW is by you. You
Yeah.
never said that you had possessed the land of twin.
My lord,
In your DW,
yes.
you should have said, yes, I am there. He was not even there for so many years.
The evidence, my lord, there are
No,
certain deficiencies in that.
We know that he has to stand up on his own legs.
He has to.
Now, once the contest starts,
Yes.
once we see that the onus is shifted upon you,
Yes.
you could have said, no, I'm not going to give evidence in this case.
Yes.
They have not been able to establish anything.
Yes.
But the moment you volunteered,
Yes.
you chose to give evidence. This evidence is of relevance. We have to look into it.
Yes.
In the evidence, they have never said that you are in possession of it.
Look, that is the
If
issue.
you are not in possession,
Hmm.
you do not even assert that you are possessing.
Yes.
Then it will be very difficult on your part to say
Yes.
that regarding his claim of long.
My lord, the fact remains that first of all, my lord, he has to show that he was in possession. In the plaint itself, it is said that I am in possession since long time.
Yes, he has said.
And in the
What Mr. Manan is saying is not his evidence, it's your evidence.
yes, I
You
know
said
that.
that you are in 226, 227.
Yes.
But you have said, demonstrate, I don't even know what is 220.
Yes, my lord, the fact of the matter is that all the witnesses of the defendant say that 225 to 26, whereas they should have said 223. That
No,
is the
even
difference.
you.
Yes, I'm talking about myself. Yes.
If rest of the defendants,
Yes.
you,
The dark
you did
number.
not say
Yes.
that I am, you could have said I am in the suitcase.
Yes. Because in the
Forget about dark numbers. I don't
Yes.
know dark numbers, but I am in the land which
yes,
is
you
the
could have
subject
said
matter
that
of
I am not in the dark
the, which
number.
is the subject matter of the
That-
list.
that-
I am in
that
the
part.
position.
Now,
And I have never seen him in person.
that is correct, my lord. To that extent, my lord, that we cannot, there is a deficiency. However, my lord, the fact remains that the plaintiff
Okay, we'll consider.
could not explain.
We'll dictate the judgment after
Masud.
we'll not keep it as CAP. We'll dictate
Delivery of order.
third take on petition, whereas should respond by
Respond.
current process.
Respond.
If that should the records of the which have been received have also been carefully examined. Hearing is this on different for pronounce of the
Masud.
Hable.
third Mr. Gupta.
It is a lordship. Lordship, since the crux of the matter, lordship, here relates to the effective time and date for the commencement. So there is an order 28/2019, whereby the owner of the vehicle leads this case again after a month to enable Mr. U.C. Rabha to produce a copy of the insurance, previous insurance. In order to substantiate whether it is a continuous insurance without any break or the annual is taken after a break.
Have you got the copy?
We have made communication, but we could not get any response. Rather, we could not trace out their variables at present. So I needed to take the position there. The lordship, I am not the claimant, but I am the owner and the driver. I am for the owner and driver.
For a claimant, lordship,
I am appearing for selected judgment for 1 to 4.
It happens, lordship, if the order is reversed, then I will be liable to pay instead of insurance. But if the tribunal awarded the compensation against the insurance, now they have come with a 3-bench judgment. But tribunal in the trial court, on the basis on the ratio of a 2 judgments, the award was given.
Where is that order?
the order was dated 29/8/2019, lordship.
The judgment.
No, a order.
Oh, it is I confirm. Yeah, I confirm.
কৈ দিয়া ভাল।
Hearing. Hearing for you.
You don't have record of the,
Lordship.
don't you have the record of the earlier insurance policy?
No, our policy, the contention of the insurance company in this case was, the policy was subscribed on, I'm reading from the order.
No, we have read the order.
Yeah.
The order has said, ask Mr. Rabha to gather a copy of the earlier policy. As an insurance company, his contention is it was with the same company. The insurance was being continued with your same company. Won't you have the records of the earlier policy?
Because I mean, just 2 weeks time to check whether it may not be, that is his contention, but it was never canvassed before. It may not have been insured with Reliance at all.
No.
I'll still ask for a confirmation.
No, but I asked because for him it may be difficult because his clients are in West Bengal.
Yeah.
But for you, I think it's very easy. Whether
I'll-
there was an earlier policy with you for the same vehicle,
I'll take
if,
that.
if it is, then was it from the same or was there any?
I'll take that confirmation.
And in the meantime, you are not being able to contact your client. Have you tried to contact your client?
Not yet. I have not played with it. But the question is, if they relay the 3 judgments, my judgment was given by the trial court on the ratio of the 2 bench. Now here comes the 3 bench that is prevailed.
No, what three judges have said what? What has been said?
They have said that if the premium is given on the same day and accident takes place after 4 hours, even then the owner will be liable.
Then in that case, Mr. Gustam, is it necessary
Lordship, that
to
is
go to
why
the respect?
so my respectful submission
Have
today.
you got the
Yes,
judgment?
yes.
Where is the judgment?
So my respectful submission today, if they rely on that, then let us give in the time to verify what is the effect and how this happened.
No.
Copy of this.
Ah.
I do not have privilege.
What is the citation, Mr. Gustam?
That's the only copy I had.
Keep it. keep. How would it? We have
Lordship, this is our copy. On who is the trial court give this assessment? It's okay.
Hmm?
It's okay.
একটু রেকর্ডেড দিব মানে মই আপনার দিম কালি দিম ফোন করবো কালি দিন ফোন করবো
দিলে হবো।
কালি কিন্তু
If time is not mentioned, then midnight of the previous.
that is the convention.
Now, if time is mentioned, where in this case was time mentioned?
Lordship, in this case,
The policy
the policy was taken on 26th.
was time mentioned.
First time mentioned that it will be operative from 27. The time is also given. The special mention the policy will be effective on 27/11/2007 at 1 p.m. or not to this is what now this is a practice followed by all insurance companies. If there is a break in insurance cover, one does not know whether it has met in action. That they usually give make it prospective from 1 day later. Wherever there is break, otherwise it will be continuous insurance. Break in insurance is a standard practice followed by all insurance.
Right.
This one take the safety margin. Nothing happens.
In this case, that is theory.
That is
That is the accident that occurred at a time when there was no cover.
no cover.
And if your liability is removed, then the owner would be liable.
Yes.
But ultimately, only your insurance to indemnify will be taken off. Otherwise, his responsibility will still be there.
Yes.
How much is the thing, amount? That case,
4,56,800. It's not a very, it's an old case. 2000.
yeah, for the claimant.
Yes, Lord.
You will not have money. Anything. Hey, do you have anything to add?
This regard, Lordship, the premium has been paid on the date of the accident, Lordship. And also, receipt has been issued. For our concession, that the insurance will be covered from that day only. Because claimant has died,
Claimant has not died.
the claimant not died.
When was the accident?
Accident took place on 26/11/2008, Lordship,
26/11/2008. What time?
at 5
AM or PM?
p.m.
5 PM.
Policy was obtained on 1 p.m.
No.
5:15 p.m. Lordship.
And same day,
Yeah.
26/11/2008. Policy.
The policy was taken on 26/11/2007 at
2008.
2007, Lordship, at 1 p.m.
No. When did the accident happen?
At 5:15 p.m. Lordship.
26/11/7.
2007, Lordship,
Okay, the date.
after taking the policy.
And policy was taken on the same date
Same
at
date at 1 p.m.
1 PM.
1 p.m. Premium was paid on 1 p.m. 9,000 something.
Then are you disputing this that the policy was procured at 1 PM?
I'll just take note. Cover note at 1 p.m.
1 p.m. and
Then,
accident took place for
Then we'll say
five-
that they have covered. It's covered.
Lordship, can be taken off. I'll just see because today very frankly, honestly, Lordship,
No, no,
that
you have
remain-
the insurance policy, don't you?
Lordship, on any day, tomorrow, day after, any day. Today,
Okay. Sir, Abba, tomorrow, he has got some problem. Tomorrow, can you take it?
because I didn't know, Lordship, that Mr. A would continue as because it was returned and I thought someone else will appear. I don't know one is.
Or- or- Representing the number 5 and 6 for
Dr. C. Kolita on behalf of Donald J. from restaurant number 1.
equal for
C. Kolita. C. Kolita.
equal to 1 to
4.
4. The person has expressed or
Tomorrow.
Yes. Good evening.
Tomorrow. Kali. Itu apa? Kapan dulu? Aku lagi nak mau.
Method.
and it part of thought is a John.
May I please, Your Lordship?
Yes.
This appeal is referred for enhancement of compensation award. I am not going to discuss the facts of the case as because we have received the compensation award as awarded by the Learned Tribunal.
What are your grounds of enhancement?
Grounds, Lordship, the deceased late Omia Das was working as a laboratory technician cum nurse in a private institute, but Learned Tribunal has not considered her income on that ground that the salary certificate was not produced, but the claimant produced some documents relating to the completion of nursing course certificate. These are Exhibit 8-9, nursing course completion certificate, Exhibit 10, nursing practical certificate, Exhibit 11, employment certificate, and Exhibit 15, that is the identity card issued by the institute. And hard is Exhibit 15.
Yes.
As per Exhibit 15, she was working 15 and 11. She was working.
11 is what?
11 is employment certificate. And 15 is very clear. She is working as a laboratory technician in a private institute at Guwahati.
Where is your appointment letter?
Lordship.
Where is the appointment letter?
Exhibit 15. Exhibit 11.
11 you said employment certificate.
Employment certificate.
Letter?
Letter is not there, but identity card is there. Exhibit 15.
No, aren't you given an appointment letter?
No letter.
Then how were you inducted in the service?
Lordship.
How were you inducted in the service?
I was working as a laboratory technician.
How? What manner? Weren't you given a letter of appointment?
Perhaps letter was there, but they are not exhibited. But perhaps the DC misplaced this document.
Thereafter, what happened? Now, from this the exhibit, can your salary be ascertained?
Not salary, but national income in the year 2014, only 5,000. It is for a nurse. How can survive in Guwahati city? Merit person.
No, that is
5,000
assumption.
is very lower.
No, that is assumption. If you do not have a salary certificate, did you give evidence regarding your salary?
I did not given any evidence, but the documents, identity card was there. No salary proof is there.
No, did you give oral evidence?
Oral evidence is there.
How much was this?
10,000. In my averments of the evidence on affidavit, I have stated that she earned rupees 10,000, about 10,000 as a nurse cum laboratory technician. Lordship.
Who was your employer? Employer gave evidence.
No, not given. Because as per the version of the claimant, that the institute was closed. Not closed, the ownership was handed over to some other person.
What was the name of the institute?
Omiya Das.
No, not the name of the institute.
Name of the institute was Healthcare Diagnostic Center Private Limited, Prague Plaza, Phongagor, Zias Road, Guwahati 5. Identity card was there, issued by the same institute. My submission is just 5,000 is very low. It will be enhanced.
Unless there is some document.
And no documents was there in support of income.
In spite of there being documents, there are cases where tribunals do not take those documents into consideration.
Definitely, but
here there is no document at all.
Yes.
How do you base your case? For enhancement, you have to make out a case by sufficient documents.
more grounds are there. Lordship, the date of accident was 5/12/14, and the deceased was admitted in GMCH ICU for 2 days. And I have submitted exhibit 12, 13, and 14, that is medical bill issued by GMCH, 5,320 rupees. But this was not considered. Nowhere reflected in the judgment. No medical.
5,000.
As per the documents, but there another expenditure was there, but some documents were lost. I have submitted the documents of 5,320 rupees. Exhibit number 12, 13, and 14.
Yes, Mr. Secretary.
Lordship, more grounds.
What are the grounds?
Lordship, as per the Magma insurance case, each of the legal claimants are entitled to rupees 40,000 for loss of conservatorium. Parental conservatorium is there, but only 40,000 was awarded, and it will enhance 10% up every after 3 years. This was not given. Only 40,000 was given.
Who are the dependents?
The husband and two minor, one minor son, one minor daughter, two children.
Here only 40,000 has been given.
Only 40,000
Lump sum.
lump sum.
And it has to be increased.
44,000 into 3 as per the magma judgment.
40,000.
40,000 but 10% enhancement.
After how many years?
3 years. It was passed in 2018 as a relying upon the pronunciation judgment.
Where is the just?
Pronunciation judgment.
No, the magma insurance.
Yes, I have. In last page, point number 18.
Yes,
Loss of filial concept.
Point number?
Point number 18.
18.
In page number 8, last page.
Yes.
Roman 10, loss of filial consortium here, 80,000, 40,000 each was given. In this case, my case is separate, different. That's it. Laban effect, loss of Laban affection is also there in point number 18, 50,000 each. That was also not given.
Here, where do you get 40,000?
In para number 18.
Yes, loss of
Filial consortium, 80,000 in bracket, rupees 40,000 payable to each.
Where do you get?
40,000 into 2 per 80,000.
No, this net 40,000 paid.
80,000 here. In page number 7 also there. In the present case, we deem it appropriate to award the father and sister of the deceased an amount of rupees 40,000 each for the loss of filial consortium. Page number 7, last 2 paragraph from the last 2 numbers.
Yes.
Lordship, hereafter the rate of interest. The Honorable Tribunal awarded 7% rate of interest from the date of filing till relation. But I am going to submit your Lordship own judgment. Recently passed, Srimati Durgavati Devi and others versus United India Insurance. Your Lordship yourself considered 9% interest. And national income was taken 7,500 in this case.
That they have given the evidence to 3 persons, including he was a self-employed. He had 2 electronic shops, one at Bonihar, one at New Palalman. There are 3 employees. Even then, 4,000 was taken. Under those considerations, he was having fearless policy. Remember this.
Rate of interest may be on.
Rate of
5,000. I am going to submit that 5,000 is very low.
There has to be some basis. Have to be do, but without there being any basis.
As a nurse, something, I am an advocate.
No, there has to be some evidence.
Evidence,
But
oral
if there
evidence,
is no evidence, only by assumption can we keep
no documents was given, but environment was there.
it. If you are employed somewhere, your government should not do either if to your income tax return or any other document. These are all documentary things. Not something which you feel. It is there is some evidence. Anything else? Yes, Mr.
As regards income, rupees 5,000 was correctly taken, at that point of time, there was no document.
Your Mr. Dekar.
Data.
The Dekar is saying that already it was deposed at 10,000.
In cross-examination, the claimant had admitted that no documents were exhibited for support of that. And exhibit 11 lordship, which is placed before the tribunal lordship.
What is the exhibit 11?
That was of 2009. Exhibit 11, the identity card of being a employee of that 11.
11 the employment.
Employment certificate. That was of 2009. Accident took place in 2014. So at that point of time, whether
11 is of 2009.
2009 not accident 2014. So it is not known whether he was at employment at that point of time or 2014 accident, exhibit 11 employment certificate of 2009. So he may not be at work at that point of time. So 5,000 lordship is quite reasonable, myself.
Other points.
Other points of the medical expenses, he is entitled, I think, lordship. It is on record.
How much?
5,000 something.
5,320.
That is, this was for medical expense.
Documentary expenses, but there are some traveling and attendance charges. These are not bill, having without any bill.
5,300.
It is a documentary proof. 5,320.
Whatever is the documentary evidence that may be considered, his submission is that if more expenses were incurred.
For medical.
Yes. 5,320 rupees.
Thereafter.
As regards lordship, Magma judgment, there's one is their lordship that came later on. Filial consortium and causal consortium, they are entitled as part of
40,000.
Yes.
There are three depends.
Because in this case it is written as loss of consortium, that it will be considered as loss of causal consortium. And other two, they are two minor sons, so they are entitled to filial consortium.
Parental consortium.
Parental.
Parental will be how much? Causal will be how much? Same 40,000.
Same.
Husband would be
Causal consortium for husband, 40,000 that was given by the tribunal. But the backward decision was not at that point of time, I think. So it came later on, backward.
2018.
Yes. Judgment was passed.
Yeah.
Courts are giving this type of judgment is based on magma is followed.
So it might increase by 80,000 and 10% enhancement.
10% enhancement after every 3 years. That is not in magma, but chronicity is followed in this. In magma, there is no mention about 10%. Only in chronicity it is.
Yes.
As regards interest lordship, at that point of time and even now, 7% interest is quite reasonable. Present day bank rate is very low. It's, only in fixed deposit also it is not more than 6% from at that reason. It depends upon the state of economy. Present day interest is not so much. So My submission of 7% interest is quite low.
Lordship, loss of estate was not given.
How much is the amount?
15,000 into 10% and
Yes.
loss of estate not given in the judgment.
As per Ponocity,
Loss of estate 60,000.
10% and
After
every 3 years, it was passed in 2018. Now
2007.
2020.
of 16,500 people come after addition of 10%.
how much will be?
16,500.
Loss of estate is how much?
16,500.
15,000.
15,000
Earlier,
after
15,000,
increase of 10% will come to 16,500 now.
That means there can be a consensus so far as consortium is concerned, which has been given as 40,000. That has to be on a per head basis. So for the children, for 2 others, 40,000 each, and all these 3 amounts of 40,000 is subject to 10% enhancement by 3 years. That is the enhancement is as per Ponocity. You were saying that 5,000 is not unreasonable. That not come, and that too the certificate I card being of 2009 and the accident being of 2014. Yes. 7% you are saying is a reasonable one. And you are agreeing upon the medical expenses of 5. Yes. And the loss of estate, which after enhancement is 6,500. Are preferred for of for by MP one for representative for
Okay.
Written matrimonial appeal, my lord. I am appearing for the husband. My colleague is appearing for the wife. I am against the my lord judgment. The divorce quash has been granted. I am basically challenging the amount of alimony, my lord. 26 lakh alimony has been. Well, lordship may take up for some other day, my lord, if not otherwise inconvenient, my lord.
Have a date.
Well, any day, lordship, subject to your lordship.
Preferably in the first week of October, if it is possible.
Fix the date. Possibility of time cannot allow. It be done. It- Elected to by this month. By October. First week of
First week.
days. Can try next.
Yes,
Can have it on 28.
my lord, my senior will be out of
Who is
picture.
this?
Mr. B. Rekam. Appearing on behalf of the,
BDEC.
yes.
Vibudec.
Yes, ma'am. So 28 till 30 will be
Okay,
out
we
of
will have it on 3rd of October.
Third.
It's the Tuesday. Right.
obliged.
Obliged.
Madam, what's the matter?
My lord.
Tuesday.
Take some time.
Hearing matter.
Hearing.
And same.
Yes.
Have a date then.
Yes, sir.
You are challenging some award.
Yes, sir.
Employees insurance.
Yes, sir. Substantial question of law or
formulate.
Yes, sir.
Which date? Same date on October 3rd.
We can try lordship for October 10 because third is already that matrimonial.
Third. Third.
Hello.
I